So good afternoon. Um, Welcome to this symposium on EU citizenship. Thank you very much for being here. I see here many of our students of the English courses, so we're very happy to see you here. And in this symposium, we will discuss the EU citizenship, and particularly the barrier who prevent the European citizens to exercise their right. And this will be the final event of a huge project, the EU Citizen Project, and we will present part of the research result. We have been lucky enough to have here together with us our rector, Professor Paolo Collini, so thank you very much for being here, and I give him the floor.
Well, my warm welcome to all of you. I thank you very much for being here today at the symposium. It's a pleasure for me to have a chance to say a few words. I'm not going to get into the issue, technically speaking, but I think that I would say a couple of things. The first one that is I was born that Europe, as we conceive Europe, the European Union, European institutions, was not an issue for anybody. And the fact that now we have the chance and we are called to discuss issues like the civil rights and economic rights of European citizens means that Europe exists much more than maybe we perceive. So that's something that personally I realize with a great pleasure, and because I'm part of the people, I think still the majority of the people, I believe, that think that Europe as an ideal thing, and Europe as a political thing, Europe as an institution, is something that we have to look at with hope and wish. So maybe I'm old enough to remember when the discussion was about the Second World War, the reasons why people got together to discuss about doing something differently from what was done in the past. And the idea of being a European citizen is a very strong concept. I remember the day when on my passport, the thing that was EU was there, I realized that something has changed. And of course now it's quite normal for most of us we cross borders, we spend money without thinking where we are. We don't speak the same language, but I think, get along with that quite well. And so I think that's very important. I'm very pleased that the Faculty of Law here in Trento has been part of such an important project, a very large, huge project, to build the foundation of European citizenship, civil and economic rights. That I think will be very important for the people that will deal with the legislation in Brussels and Strasbourg, to have the opportunity to use such large amount of work that was done to put together the incredible amount of things that you can probably put together today on this issue. So that's the first part of my point. The second thing that is Europe is always very hot issue. Today maybe even more than some other days. And the fact that we deal with some changes in the European Union can probably be seen as a negative thing. But we have to remember that we have been witnessing many times the fact the European Union was enlarging. I got to know the European Union, there was Europe 6. That tells something about my age. So now we still deal with the Europe 28, 27, 26 maybe, but still much more than 6. So the very strong movement of creating a larger and larger Europe has been, of course, always balancing between the effort of making Europe something more unified, and the effort of making Europe larger. The two things have been going on together with some stop and go, but I think that even though today unfortunately we see a negative point in that process. If we look in the long term, we can see that a lot of things have been done and a lot of work has been put in creating a larger and better and more unified Europe. And unify means not necessarily that we are all the same, not necessarily that we do all the same things, but unify means that together we have something to share. We share something we believe in, we share something, common values, we share a vision of what the future should be and will be, because we'll do it. So thank you very much for being here today, and thanks for the work that's been done.
Thank you very much. And I'll address myself to the student, just to say that for you, it's the fact of traveling around Europe without showing the passport or the identity card is something that you take for granted, but it was not like this in the past. So it's something that we have to continue build up and together. So I completely agree, and thank you very much for this message. So I now give the floor to Professor Luis Antonioli, who is the Vice Dean, and will address the greetings for the faculty and on behalf of the Dean, Fulvio Cortese.
Yeah. Well, thank you for all of you. Very brave to be here on a Friday afternoon when the classes are over and it's snowing outside. So very happy to see you around. I'm thanking you on behalf of the faculty and on the behalf of our Dean, who couldn't be here with us today. And let me first thank Elena and Professor De Vries for all the work that they've done, a lot of meetings, a lot of colleagues in Trento and elsewhere that were involved into the project. I look at the books and they're really amazing amount of work. And I think somehow I'm happy that we are doing it today with this bad news from at least my point of view, I think from point of view of many people of the British election results, which almost certainly will lead to Brexit. It's now really close. And of course, it's a sad day. It means that one of the important members of the Union is going away for reasons that are very much related. I mean, these were national elections, but Brexit was very prominent in the debate. And I think it's good to have it today because that's a challenge. The idea of citizenship, of European citizenship, lies at the core of the debate that there was running in the UK and finally led to deciding that they want to quit. So I think we have to be reminded of the thing that there's nothing that we can take for granted. As Paula said, we've been building Europe over many decades. We've achieved incredible successes. The Union is by far the most successful example or experiment of regional integration. But there's nothing that you can take for granted, not even a successful enterprise as the European Union. So discussing what is the content of the European citizenship, civil rights, economic rights, how this relates to our national identities, how this is going to develop in a union that is far more different than it used to be in an international context that is changing very rapidly, I think is fundamental. So I'm proud and I'm happy that it's going to take place today, and I'm sure we're going to come out with a lot of interesting things. And I'm very happy that there are a lot of young people in the classroom, because I have to have the sense that this is not over. It has to be constructed. So you're part of it. Thank you.
Thank you very much, Luisa, for this positive message. And before starting, I would like to spend just a few words about the collaboration between Utrecht University and Trento Faculty of Law and on the BU Citizen project. The collaboration between our faculty started already 15 years ago when we built it up together, the transnational law program that at that time was the first example of transnational legal education in Europe and probably around the world. And after the transnational law program, Professor Siebe de Vries, who was the coordinator, was appointed coordinator of this huge project, invited us to join the consortium. And we were so involved in a very, very stimulating environment, and in Trento with a very great coordinators, of course. We are been very lucky, and we are also built up a very nice team in Trento with some scholars who at that time were very young scholars, but they're still young. Paolo Guarda, Elisabetta Pulice, and Flavio Guella, who were really the engine of the program in Trento. And so today we are going to present part of the result of this project, and particularly 2 of the 8 books that are edited by Edward Elgar Publisher. And the first one deals with economic rights, so the barriers that European citizens have to face in order to exercise the economic right composing their status as European citizens, and the second one on the civil rights. Both the books, particularly the one on civil rights, contain this research that might be interesting for jurists, national jurists, and national judges. Particularly from the point of view of constitutional law and fundamental rights. And so, for this, I would like to thank again Professor Siebe de Vries and also our keynote speakers, particularly Daria De Pretis, who, notwithstanding the commitment of the Constitutional Court, kindly accepted to open the symposium, and Catherine Barnard, that is this very, very delicate and challenging period is together with us. She was also a member of the advisory board of Biocitizen Project, and she gave an important contribution. So thank you very much again, and I give the floor to Professor Daria De Pretis, who is Professor of Administrative Law, former Rector of Trento University, and Judge of the Italian Constitutional Court. So thank you very much, Daria.
Thank you, Elena. So, dear Elena, dear colleagues, director, of course, and dear students, let me firstly thank Elena Ioriatti and Professor De Vries for the invitation. It's really important, and in some way, I would say also symbolic to speak today of EU citizenship here with Christian Barnard and with all of you in such a day in which we read about the results of the election in the UK, and we are trying to figure out what can happen now. But as our rectors told us before, we are now in any way in a larger, in a stronger Europe. He told about the boundaries and you can imagine how old I am when I tell you that I studied in Berlin when Berlin was called West Berlin when I studied there, and the wall was there. And when we want to go from Trento to Innsbruck, we had to show our passport. So it's really a very different Europe, and everything changed, not rapidly, but with a reasonable speediness. So I think we must be we must preserve our hope with our how can you say, we are united in diversity, and Europe is really this concept. And speaking about EU citizenship, we can experience that is truly so. So I'm very pleased to be here today to open this symposium on citizenship, which is a very important concept in public law, of course, and even in European law, as we are going to see. This is so a very traditional concept, but at the same time a current one. The citizenship of the European Union is a status. It was established by the Treaty of Maastricht, And in this status, some special rights were formally regulated for the first time. Examples are the right of free movement and residence, or the right to refer to EU institutions and organs in one of the official languages, which are many, as we know. Such rights make up the status of EU citizens, of which people are holders as they are citizens of a member state. Article 20 of the Treaty on the Functioning of the European Union establishes, in fact, that every person holding the nationality of a member state shall be a citizen of the Union. And with reference to the European citizenship, the Charter of Fundamental Rights assigns the value of fundamental rights substantially to the same rights. Thus, the status of EU citizen is composed by specific rights listed in the treaties and in the Charter, but is at the same time expandable. Firstly, the number of rights could be increased according to a special legislative procedure regulated by the treaty. Furthermore, since the Maastricht Treaty, the founding fathers of the Union have been regulating European citizenship, relying on an open concept and on a drafting technique that is typical of the constitutional texts. Not very long ago, in this same faculty, in a dialogue with you students, I showed you how the Italian constitution has an expansive strength that is both semantic and substantial. Its norms, principles, and notions were written in 1947 in a way to be able to regulate events and matters of the time, but also of today and of the future. We are facing now problems that were impossible to be thought at the time in which the Constitution was written. So the Italian Constitution was written to move through time, to regulate a still unknown future that was, however, meant to be founded on specific principles and values. In this sense, we can certainly say that the Italian Constitution contributed to the creation of what is positive in our present. The European citizenship, too, is a notion able to include new rights and open to possible future developments. Current examples made popular by the recent events regarding immigration is the concept citizenship of residency that allows the acquisition of some of the rights I just mentioned in favor of people who are not European citizens, but that are integrated in the national community of a member state as residents or because they exercise the right of establishment. So European citizenship is therefore a national and a European notion at the same time. On one side, with regard to its content, the very first rights that form this status were listed in the treaties and therefore identified on a European level. From this point of view, EU citizenship is certainly a European and autonomous notion. On the other side, EU citizenship is a national concept if we consider the way through which a person acquires or loses the status of European citizen. since they depend entirely on the regime on national citizenship chosen by each member state. So the European citizen status, therefore, depends on national legislation on citizenship and also on how such legislation is interpreted and applied on a daily basis by the court in the member states. As a judge of a constitutional court, I believe it is important to be aware that every single decision, every single choice regarding the concession or refusal of national citizenship taken in each state has inevitable consequences on the European level. Not very long ago, the Constitutional Court of Italy, our Constitutional Court, declared a provision regulating Italian citizenship unconstitutional, specifically Article 10 of a law of 1992, because this norm did not exempt mentally disabled persons from a formal condition, the oath, that was necessary to obtain citizenship on the ground of naturalization. The provision was considered discriminatory by the Italian Constitutional Court as it precluded de facto naturalization to a person even in presence of all the other requirements only because, being mentally disabled, he or she could not take the oath. So, by excluding such a person from citizenship, not only the legislation would have marginalized him or her from society, but also from being a European citizen, and therefore holder of important rights, such the one of non-discrimination. Thus, the courts of the member states, along with the European institutions, share the responsibility of building up the status of European citizen. This role is crucial as national laws on citizenship could unintentionally be the very first barriers to the enjoyment of EU rights, hindering the most important one, the right to have rights, as European citizenship was defined, borrowing the famous word of Hannah Arendt. So, all this demonstrates that many barriers to the enjoyment of EU citizens' rights are actually just boundaries. They are not geographical boundaries, but juridical ones that mark the point at which Europe and its member states meet in the process towards European integration. Sometimes these boundaries are legitimate. They are expressions of the national sovereignty. Again, this diversity and unity together in Europe. A natural example is the conferment of citizenship, since it is up to each state to decide who its citizens are. Excluding the European Union from determining the criteria for the acquisition or loss of European citizenship is a way to safeguard the sovereignty of member states. It is the treaty itself that establishes that the citizenship of the Union does not replace national citizenship. On the other hand, it is also up to each member state to ensure that the right to European citizenship is fully enforced on the national territory too, regardless of any boundary. It is in this context the Court of Justice of the European Union is playing a very important role, since its case law on European citizenship is constantly seeking for the balance between the citizens' rights and the sovereignty of the member state. Thus, the case law of the Court of Justice has opened up a dialogue also regarding boundaries. Within this framework, the barriers that were uncovered by the BEU Citizens Research Project, your project, Elena and Sibe, highlight an important phase in European integration, allowing us to understand where to restart from in order to keep the dialogue on these boundaries alive. Thank you very much.
Thank you very much, Daria. I think that this was a very interesting point of view, the fact of considering the barriers, simply the boundaries, because it really opened up the possibility to keep a dialogue alive, as you said, on what we feel like simply obstacle. Good, so thank you very much. I now give the floor to Professor Catherine Barnard, who is Professor of EU Law and Labour Law at Cambridge University, Trinity College. Professor Barnard is also Senior Fellow in the Economic and Social Research Council at the UK in a Changing Europe project. Again, thank you very much for being here, Catherine, and the floor is yours.
Well, thank you very much indeed for inviting me here. As you can imagine, it's a day of a certain amount of personal torment. This is probably the last time I speak at an event such as this in my capacity as a citizen of the Union. I'm having my citizenship removed in 7 weeks' time. And actually never before have British people lost so many rights all in one legal moment, a fact that I don't think most of my contemporaries have actually realised will happen. It's a really quite extraordinary event for the British public. Now, I don't want to dwell too much on that because it is a very raw wound, but I want to start by thanking you all for inviting me here, and thank in particular Sibe de Vries for his magnificent corralling of the many people involved in this very comprehensive project and actually managing to deliver it within a reasonable space of time, while you've still got at least 27 member states who are still citizens of the Union and who are benefiting from the rights about which you have all written so eloquently in the 8 books that have been magnificently produced. Now, what I want to talk to you about this afternoon is actually triggered in part by a reflection on leaving the European Union, and that is, where did EU citizenship come from? What is the idea? And what I'm going to try and argue with you was, I want to go back in time. We've already heard a very eloquent presentation of what the current situation is, but I want to go back to the 1970s and 1980s to think a bit about what was the reason for the introduction of European citizenship. And what I'm going to argue with you, I'll give you the headline now, so for those of you who've had a good lunch, you can switch off. But essentially what my argument will be is that EU citizenship was developed to address a deficit, a really quite major deficit in the commitment to the EU project by its citizens. And what it was originally there for was as part of the agenda to try and deliver on EU integration, and specifically the notion of EU identity, before becoming a key component of the greater constitutionalization of the EU project. But what I'm going to argue, and this is why my talk is called Constitutional Myopia, what I'm going to argue is that there's been such a fixation on the greater constitutionalization of the EU that it's been done to the total detriment and disregard of many of the very practical implications of this. What I'm going to argue is essentially this whole project has been led by constitutional lawyers, constitutionalists, and those in the EU institutions, with remarkably little input from policymakers who actually have to deliver this on the ground. And this may explain in part why some of the things have gone somewhat pear-shaped. Now, I hope I am fundamentally wrong in everything I'm about to say, and if so, I'd be very grateful if you would tell me this, because I haven't argued this before in public, so I may just have got the whole thing wrong. But the consequences of this overlooking of the very practical dimensions of citizenship are very serious. So, my first point is the origins of citizenship. Now, it's common parlance to say citizenship was invented by the Spaniards, and they invented it very quickly prior to the Maastricht Treaty in 1991. In fact, this is totally untrue. Certainly, the Spaniards gave the project a good kick into life in 1991, which led to the rights that appear in the Treaty on the Functioning of the European Union, the rights that Daria has so eloquently described. But in fact, if you look back at all of the literature, which is what I've been doing over the last few months, what you see clearly is the notion of EU citizenship has been around, has been kicking around since the early 1970s. And why it was there right from the very earliest days was simply because there was deep concern in the 1970s about the lack of an EU identity. There was a lack of an EU identity both internally but also externally. Now, in the 1970s, 1972, 1973, that's just after the first expansion of the European Union, there was deep concern about the so-called sluggish development of the EU project. There was a sort of great enthusiasm for it in the late 1950s, early 1960s, when the EU treaties were signed, but then it sort of went to sleep. And part of the problem is that, well, so it was diagnosed at the time, was that there was a lack of identity. Now, there's that famous phrase, I don't know whether it is actually true or whether it's apocryphal, from Kissinger, the Secretary of State in the United States, who said, well, when I ring Europe, I have no idea who I should be calling. There is no clear body, no clear, it's not, like in Italy, you'd ring the Prime Minister, you'd ring the President, it's quite clear who these people are. It's not the case, or it wasn't the case in the EU. I'd argue still it's not very clear, given that there are 5 presidents, but that's for another day. But the absence of a clear external identity was a matter of really serious concern. And there was a declaration, indeed, in 1975 on European identity, trying to get to grips with this issue. But it wasn't just an external problem, it was also an internal problem, a problem that actually still resonates today, and that is that there was real concern by the EU institutions that individuals felt very remote from the EU institutions. And there was real concern that there was a lot of discontent and alienation in the member states of the people from the EU. The EU was seen as very remote indeed. And the Commission reported on this in the mid-1970s. And Tindemans wrote a report, and you can see here something rather telling. The European idea became partly a victim of its own success, since after the reconciliation between formerly hostile countries and a period of economic prosperity, the Union seemed to have achieved its purpose and thus lost its air of adventure. In other words, it had gone to sleep. People had got bored with it. And so something needed to be done to try and deliver on the EU project. And so the answer they came up with was the creation of the European Union. Now note, we are talking 1972 here, not 1992. It's 1972. There was a summit, first summit conference of the enlarged community, and the member states set themselves the major objective of transforming before the end of the present decade, and with the fullest respect for the treaties already signed, the whole complex of relations of member states into a European Union. But the identity issue, i.e. people not identifying with the EU, people not seeing it as a project for them, dogged the creation, got into the way of the creation of this European Union. And this led to the development of the idea of a people's Europe, which eventually metamorphosed into the notion of EU citizenship. And see, look, we're talking 1974 here. The European Parliament had a resolution, noted that a European Union had to evolve towards a closer union between the European people. So what you've got even back then is the link between identity, legitimacy of the EU project, and the building of the European Union. And this debate, there's lots and lots of documents. I've just pulled out one or two so you can try and see the direction of travel in which I'm talking. As you can see, the idea of a people's Europe now as a central building block of the European Union project continued to resonate through the 1980s. Take, for example, the resolution on the people's Europe in the Fontainebleau summit, where the European Council said it was essential that the community should respond to the expectations of the people of Europe by adopting measures to strengthen and promote its identity and its image, both for its citizens and for the rest of the world. And can you see again, you've both got the internal and the external dimension. The internal, individuals need to be committed to this project. External, there's got to, it's the Kissinger question. Who is the rest of the world dealing with in the European Union? Now, again, while the common narrative has it that the Spanish invented citizenship, is actually the Italians. That's the closest I can get. So, 1972, it's the Italian delegation called for, and I quote, an examination of the conditions under which and the timetable according to which European citizenship could be granted to citizens of the then 9 member states. So you've got the language of EU citizenship already back in the early 1970s. Now, what's interesting is that there were lots of documents being published around this time, but essentially the heads of state called on the Commission to work on 2 strands of the project, the passport union and what has been called special rights, and indeed the Commission produced 2 papers, 2 reports of 1975 on these 2 subjects. And what's interesting is that those reports are called Towards European Citizenship. Now, why am I giving you all of this? You must think, God, this seems like ancient history. This is very dull indeed. But what I'm trying to get you to see is that if you go back in time, you're seeing the seeds of what I'm trying to argue, that the notion of citizenship was connected to a political project which was about the creation of the European Union. Now, the idea behind a passport union was originally that everyone should have a single passport, so they should feel committed when they travelled, but it evolved quite quickly into something much more ambitious about what Dario was talking about removing barriers for people to travel freely between the member states without having to show a passport. And it evolved into police and judicial cooperation. As far as special rights were concerned, that seemed to be a bucket into which to throw anything that anyone wanted to. And over time, that bucket contained something to do with fundamental rights, something to do with political rights, I'll come back to that in a moment, and also, again, it varied in time, but also something about removing of borders. But what is striking in this period is citizenship seems to be particularly closely aligned to the notion of political citizenship, i.e. the right to vote in elections in other member states. And so if you think about the traditional 3 pillars of what constitutes citizenship at national level, the 3 pillars that were developed by T.H. Marshall, the sociologist, that it's got social rights, political rights, and civil rights. In fact, what was being proposed at EU level was somewhat asymmetrical, because what was being proposed was essentially quite a lot about political rights, about the rights to participate in elections in other member states, and also the need for universal suffrage in respect of elections to the European Parliament. So what you see essentially in that period of the late 70s, early 80s, is the evolution of something rather new, what Mian's described as post-national political European citizenship. But also what you see is, under that heading of special rights, remember I said it was a bucket that seemed to catch all sorts of other things, there was a good amount of repackaging of what was already in the treaty and calling it citizens' rights. So they talk about the rights to free movement, some of the social rights, and crucially, equal treatment. And all of this is done to bring Europe closer to the citizen. So why is this interesting? Because all of this eventually led, in 1991, to the discussions between the Spanish and also the Irish about how the notion of EU citizens could be incorporated into the treaty. And essentially what you see is the Spanish government says, what we need is a political union, and that political union will have 3 legs: economic and monetary union, common foreign and security policy, and crucially, common citizenship. So you can see how citizenship is directly linked to the establishment and the creation of a political union. And just look at the presidency conclusions of the Dublin European Council in early 1990s, how, among the overall objectives of a political union, the question of how to include and extend the notion of community citizenship, carrying with it specific rights for the citizens of member states. Note that language of specific rights, that catch-all bucket that keeps popping up by virtue of these states belonging to the European Union. And as we know, the Maastricht Treaty, as Dari explained, then did contain those rights for EU citizens. And I think it is also worth mentioning in this context the role of the Court of Justice. And I think you're all familiar with that decision in the unpronounceable case name that we anglicise as Brzelczyk, but it's not pronounced like that at all. Perhaps the most famous case on citizens' rights, where the court says union citizenship is destined to be the fundamental status of nationals of the member states, enabling those who find themselves in the same situation to enjoy the same treatment as nationals of another member state. Why is that so significant for my narrative? One, because it's using the language of constitutionalization. It's making citizenship the fundamental status of nationals. It's linking citizenship to equal treatment. And it's the Court of Justice declaring it top down. Why does that matter? Because actually the consequences of what the Court of Justice is saying are really quite far-reaching. Because essentially citizenship means that a French national can invoke rights against the Italian state. It's a horizontal application. It's rights being bestowed by the EU, but being borne by the burden of those rights being placed on host member states. It's making dramatic inroads into the sovereignty of member states and their ability to control not just access to their territory, but access to their social policies as well. Now, I imagine everyone in this room thinks that's a very good thing, not least because most people in this room have benefited from it in some form or other. But what you're seeing is you've got the EU institutions and including the Court of Justice, all working together to see the creation of European Union citizenship as the zenith, the high point of the EU project. Now, so far, what I've told you probably is rather familiar territory, and most narratives would stop at this point to say, look what a remarkable thing the Court of Justice has delivered. But what I want you to see is, can you see how the narrative I've constructed here is entirely a constitutional one? It's focused entirely on EU citizenship being there to help create EU identity and subsequently to become a key pillar of the EU constitution. It's being led by the EU institutions. And the reports have been written by those who are party pre to the EU project. And the commentators who are writing about it, and here I may well need to be corrected, are largely constitutional lawyers, academics who are constitutional lawyers. So Joe Weiler, Chief O'Leary, Joe Shaw, Elizabeth Meehan. And I imagine it's the same in Italy, but I'm not sufficiently well aware of the Italian literature on this point. My point is that it is being delivered by constitutional lawyers as part of a constitutional building exercise. Why is this so remarkable? Because the narrative I've given you so far is a reasonably standard narrative, but what I don't see in any of the literature is any discussion of what's missing. And by that I mean, who was not involved in the project? Who was not at the table? What was not discussed? Now, we rarely consider that counterfactual. But if you ask those questions, who was not there, what was not being discussed, and what was not being done, you get a rather different perspective. What's not being considered is the costs for the states who are having to bear the burden of this EU citizenship. What's not being done is any risk assessment of the implications of opening up the social welfare systems of the host state. What's not being considered is, where are immigration lawyers in this? Where are policymakers who have to operationalize on the ground the delivery of these points of law, the principles of equal treatment for EU citizens? None of that's there, because this whole project's been entirely conceived from a constitutional perspective, rather than, and so top down, rather than bottom up, who is actually going to deliver it and what are the implications of all of this. So the implications are, it was a debate on EU citizenship, a debate between constitutional lawyers and theorists, all talking to each other, all taking the view that more Europe, more EU citizenship, more EU rights is an unadulterated good thing. And of course, people like that would say that because, like all of us in this room, we have all benefited from it, because we have all exercised rights of free movement. But if you have never exercised a right of free movement, all of this looks like it is benefiting other people, and it's not benefiting yourself. The implications of all that I have just described, in particular the application of the equal treatment principle, remember the equal treatment principle being applied to other member states and other member state taxpayers who are having to pick up the cost. The implications of all this were only realised too little, too late. You see a little bit of it come up in the Brexit negotiations, or at that time the Brussels renegotiation, the failed Brussels renegotiation in February 2016. And you also see it a bit in the Court of Justice case law, when the Court of Justice does what looks pretty much like a 180-degree U-turn on its case law in decisions like Bray and Dano, where the court suddenly turns a lot of its case law on its head. Yes, the rhetoric from Grzelczyk is still mentioned, but the outcome of the decisions is actually very different. But it was too little, too late, at least for my own country, where the fine words of citizenship and solidarity and identity were insufficient tools against the power of the media and public perception. This is a summary of all of the front pages of the Daily Express, one of the tabloid newspapers in the UK, in the period January 2014 to June 2016, so 18 months. Now, it's probably too small for you to read, but the bottom line is, from all of this, is that migration of all sorts, of course confusing both EU and non-EU migration, is unremittingly a bad thing. This is slightly larger for you to read. This is another set of newspapers, but equally anti-migrant, the Daily Mail. But what you see is the power of the press and also public perception in areas like parts of East Anglia, small market towns where they no longer, they say, no longer hear their own language spoken in the street. Now, of course, what we are seeing is a lot of EU nationals, primarily from Central and Eastern Europe, coming and working in the fields and doing jobs that a lot of British people, myself included, wouldn't want to do. But the fact is, it's an identity issue. And the question about identity, individual towns losing their identity, to a lot of these towns that voted to leave. And this chart was a snapshot taken on the day after the referendum, on the 24th of June, as to why people voted to leave the European Union. And the larger the font, the more salient the issue. And what you see is quite clearly the principal reason why most people voted leave was about immigration. And actually what you saw in the election campaign that finished last night, that there is much greater freedom now to say some pretty offensive things against EU migrants, including the Prime Minister himself said some pretty offensive things about EU migrants, which were in the Times just this last week. Now, I'm not saying EU citizenship led to the Brexit referendum, but what I am saying is that although EU citizenship has delivered many good things for many people, it is just worth bearing in mind that a lot of people have not been beneficiaries of the EU citizenship project. And in fact, for many people, rather than EU citizenship making them feel more identified with the EU project, the some, certainly in the UK, it's had the effect of pushing them away from the EU project. EU citizenship, developed by constitutional lawyers as part of a constitution building strategy, at least in the case of the UK, has backfired very badly. Thank you very much indeed.
Thank you very much, Catherine, for this very, very interesting insight of the European citizens. We have now many questions in mind, and I know that there are questions already. So I would suggest to open the debate, just few questions, because time is running. But if there is any question, this is the right moment to ask.
If I may, if nobody else is looking for a question, sure, the students? No? Nobody? Okay, we have. Yeah, of course. Let me get you the micro.
Oh yeah, I can. Thank you very much for both of your really inspiring, intriguing presentations. Yeah, it is on. Thank you very much. Yeah, it works. Okay, I have a question, Catherine, to you regarding your presentation and this mismatch between, on the one hand, you could say constitutional narrative or constitutional speak, and on the other hand, the policy implications on the ground. But couldn't you also say that actually, especially in the 70s, where we see a lot of policies being developed, policies that include a narrative on EU citizenship, that in itself, that is not really an example of constitutionalization, because it's precisely, you could say, politicians, states, member states being involved in shaping EU citizenship. So how would you really describe that as a part of a constitutional narrative compared to indeed including EU citizenship explicitly in the Treaty of Maastricht? Because you could say, well, it's also a bottom-up approach apparently in member states seeking to wish to include something which refers to citizenship and identity. So how would you look at that from that perspective? Thank you.
You want to have some other question, or you prefer to answer?
Yeah. Thank you very much, Catherine, for your very nice presentation, though I feel a bit depressed now. I wrote a whole book on constitutionalization and EU citizenship, so I'm guilty as well. And what struck me actually, so I think I agree almost on everything you said. I'm also wondering how you see other case law fitting in. So you talked about Dano indeed, which is of course a U-turn by the Court of Justice. But on the other hand, I also see the Court of Justice actually connecting EU citizenship much more with fundamental rights. So the rights of the child, for instance, in Chavez, in Chavez. So you see on the one hand, the court is, you know, giving back a bit more to the member states in the field of social rights, but also protecting citizens more on fundamental rights, perhaps. So how would that fit in your idea? And my other question is more a kind of practical question, maybe. If I remember well, in the time of Cameron, he was very offended by in-work benefits. And it always struck me that in that whole debate on Brexit at that time, in-work benefits were kind of key in the national debate in the UK, rather than economically inactive citizens. So maybe you could also reflect on that. And as a remark, I always tell my students EU citizenship is in between a rock and a hard place. So either people think it does too much, or either people think it does too little. So somewhere I also feel like people are overestimating what citizenship can actually do for people. Thank you.
Can I add one question? I was fascinated by your speech, and there's a question that comes on a number of issues again and again about European integration, and that's the kind of chicken and egg problem, because the idea is that you're looking for identity building, and the thing is that do you first build an identity and then go for the European citizenship, or you do it the other way around? And apparently what we have tried to do is to do the other way around. You first convey European citizenship, which is a kind of fuzzy things. You repack things that were already existing, and then you develop a process whereby you add bundles of rights in the box. And I have the sense that maybe this is because we have a kind of path dependency on spillover effects. So Europe has been doing almost in every area to start with small steps and thinking that over time this will gradually lead to full integration. And I think there's a limit to that, and probably constitutionalization And citizenship is one of the areas where this kind of process has particularly hard limits to overcome. And finally, there might actually backlash, as it was the case. And I think that in that sense, Britain is not isolated. The kind of reaction that we've seen in the Brexit debate is something that we're witnessing in many other member states today.
Thank you for those insightful questions. On your last point, I think what is intriguing about EU citizenship is it's doing two things at once, and I think that's part of the problem. It's being there, it's there to try and create identity, and yet it's also there so people feel connected with the EU, but in order to do it, it's giving them things that a lot of people can't take advantage of. A lot of people don't move, and I think it's quite striking that in the UK, 1 in 6 people don't have a passport, and pretty much all of those who don't have a passport voted leave. So there is already, already all of this talk about connecting people with the EU, actually for some groups of people it really doesn't have any effect at all. 1 in 4 people don't have a driving license. So it gives you an idea of that this is not actually delivering. But otherwise, I very much agree with what you're saying. In respect of your point, Hanneke, about in-work benefits, yes, you're absolutely right on that specific issue. So in-work benefits were money to top up people on low incomes. And this is a very specific British problem. And of course, a lot of Eastern European nationals were on low incomes and they had kids, so they got the top-up benefit. And therefore, a lot of people in the EU said, well, why don't you sort out your benefit system rather than try and expect the EU to adapt its rules to the UK benefit system. So I agree with you on that point. On your point about citizenship being between a rock and a hard place, I also agree with you on that. I think there is a problem that the EU has got a tendency to overpromise and underdeliver. And of course, this goes back to your specific point about the EU proceeding in small steps, and then not really working through the implications of all of the consequences of that. And in respect of SIBA, your question about am I being unfair? And in the 1970s, it wasn't just EU citizenship, there were lots of things being discussed. Yes, absolutely, you're right. And you could say it is a sort of bottom-up approach in that it was member states beginning to shape EU citizenship. The trouble is it's who in the member states, which ministries were doing it, and what's not clear to me is whether it was the ministries of the interior who were actually doing it, or whether you're dealing with prime ministerial level who think a lot about big symbols and vanity, their own legacy, rather than actually having to operationalise it on the ground. It's not clear how many civil servants from interior ministries were actually working through this question. And that's my concern about this constitutionalisation narrative. And on your specific point, was it really all about constitutionalisation? Probably not. I don't think it was in the 1970s as such. I think it was much more about creating an EU identity. But that morphed quite quickly into a more constitutional narrative. It's quite difficult to pinpoint a moment in time, but I guess about 85, 86, when they start thinking about a major treaty reform which led to Maastricht, which is getting closer to some sort of constitutional structure.
Okay, it's really a shame that we have to conclude the discussion, but I think the time is running, so we have to move to the other section. Thank you very much again to all the speakers.
So, perhaps we can start with our session. Thank you so much. I introduce myself. I am Anna Simonati. I am Professor of Administrative Law here. So my field of interest is quite specific. And the first thing I have to do is to thank my friend and colleague Elena Iogliatti for inviting me. It's a pleasure and an honor. Yeah, it is a pleasure. At least till now it is a pleasure. Let's see later on. I'm very proud to be here. I have already learned many interesting things, and I'll be very short because time runs, as you already told us, and it's true. I just want to stress what I think is a basic point for our meeting today. We have heard many different definitions of what European citizenship is. It is an issue, of course. It is also perhaps a problem, and it will become a problem in the next future. It is a challenge, but it is also an opportunity. And I think this multiple choice in telling and indicating what is the content and the function in law for European citizenship is a very interesting point for all of us. And I think that another very important element of our meeting today is that it gives us the opportunity to talk all together on the same issue from different points of view and in different perspectives. And that's why I feel very lucky and fortunate to be here today with you. But time runs, and so I immediately leave the floor to our first speakers, who are at home, and they are Professor Paola Guarda and Professor Elisabetta Pulice. So I leave immediately them the floor for their introduction. Thank you.
Good afternoon, everyone, and let me first of all thank Professor Ioriatti and Professor Sibe de Vries for the invitation and also for the opportunity to participate in the BU Citizen project. And let me thank them and also Paolo Guarda for the collaboration in editing the volume and of course all the authors. And today we are going to, to give a brief introduction, and I would like to start from a case of South Tyrol here in a bilingual province in very close to Trento. Why? Because in a few months ago, in a provincial law implementing EU law, the province decided that the Medical Association of Bolzano can limit the control usually performed on the knowledge of language that is necessary to practice the profession in Italy. And why? It is based on the fact that in this bilingual province, German and Italian has an equal status. And there was a huge debate. Why? Because it can be inconsistent with the role of the Italian Medical Association and the control on the knowledge of Italian that is necessary to practice in Italy. And this control is of course performed because based on the EU law, and especially why? Because there is also the protection of the health, the right to health of the patient, as you can see. And I don't want to go into detail of this case, but I decided to start from the specific case of the linguistic requirements imposed upon health professionals, because, well, first of all, because to stress that linguistic barriers that are a part of the analysis we did in this volume are a topical subject, but also because it is an example of the variety of perspectives from which linguistic barriers can be addressed, can be analyzed, and an example of the plurality of factors, rights, values, and actors that must be properly considered. And this is mainly due to the huge variety of roles that language may perform at both the national and European level, and this huge variety of roles raises social, political, and legal issues in the multilingual and multicultural context of the European Union. Language is a tool for communication and integration, has also an identitarian function, and the protection of the imposition of linguistic requirements are based on the protection of fundamental rights of linguistic minorities and so on. And in Europe, this multiplicity of competing or mutually interrelated perspectives is increased by the multi-level governance addressing linguistic issues in the national and European and regional polity building and rule-making processes. And so linguistic barriers are an interesting perspective from which to analyze the rivalries of rights that are one of the main topic of this volume, and barriers to the exercise of economic rights. And in this volume, these economic rights are analyzed, well, we analyze their significance, their evolution, their application, and from the methodological perspective, we try to combine the empirical research with the categorization of different types of barriers. So there is a mistake, not only linguistic barriers, but generally barriers from a general perspective, through a deep understanding of the reasons behind these barriers. Why? Because we also try to find a strategy to cope with, to mitigate, or to overcome a given barrier. And in trying to find this strategy, we try also to distinguish between factual and legal barriers. So between barriers that, although often regulated by the law, derive from factual situation, multilingualism, for instance, and factual and legal barriers, so barriers that directly derive from legal rules. And this distinction is, we try to analyze these barriers, the different barriers, and to find this strategy in considering three types of economic rights. And now I give the floor to my colleague. Thank you.
Good afternoon to everybody. I have also to thank our coordinators for the conference and for the project, so the main and general coordinator, Sibe, and Elena, who was coordinating the University of Trento team. It has been, I've been working for the Biocitizen project. It's been also an academic and also a human experience, and I learned a lot, so I thank you a lot. My task today, as you know, we are presenting this book. It's a legal copy of the book, so it's not a legal copy downloaded by internet. So my task is to present you the main issue, the main goals of this book and the contents, and would also take the chance to present you very briefly the chapter I wrote inside. So you probably got it during from the other presentations, but the main goal was to analyze the economic rights of European citizens and the barriers they face in exercising, in enjoying these rights. As you may know, this book is the final output, one of the main output of the Working Package 5, as the book dealing with civil rights is the final output of the Working Package 7 within the Biocitizen project. So the idea was to analyze and to study the possible barriers and obstacles that EU citizens may face in dealing with these rights. We actually took three main case studies, three important economic rights that we studied using a cross-national approach. One was the consumer rights, the second one was rights of professionals in gaining access to the market, and the third one was intellectual property rights in the light of the digital single market. Of course, the way we test these rights was, again, the legal and the dichotomy, legal and factual barriers. So we try to study and to pinpoint and to detect possible legal and factual barriers that EU citizens may encounter, may face dealing with this right. The book actually is organized in this way. It's divided in 4 parts. The first one actually was an introductory part dealing with critical overview to EU economic rights and barriers. We have chapters of Sibe de Vries and of Flavio Guel, another colleague from Trento, introducing the issue, proposing the main definition, the main criticalities with reference to the topic. The second part was dedicated to the 3 cross-national studies I was presenting you before. So legal and factual dichotomy of barriers to economic freedoms based on the 3 cross-national studies, case studies. And here we have 3 chapters actually. One chapter from Silvia Adamo and Tom Binder dealing with professional qualification. So the second point that was presented in the last slide before. Another chapter from Anne Maria van den Bosch and Maria Teresa Solis Santo dealing with consumer rights, in particular with reference to geo-blocking and geo-filtering. And a chapter by me dealing with intellectual property rights, in particular dealing with copyright from this approach. I'm going to spend a couple of words presenting you the main line of my chapter. And actually, of course, creativity and innovation are part of an harmonized system of protection at the EU level, but also at the international level, the harmonization is quite strong, thanks to or due to some treaties, conventions, regulations, or also due to many international bodies like WIPO, so World Intellectual Property Organization, World Trade Organization, local and regional organizations and bodies like European Union, that actually fully harmonized or try to fully harmonize the system. Of course, the digital technologies play a pivotal role within this context, of course, because they truly or they very strongly change our life and transform our way of living. And also from the point of view of my chapter, of course, they also affect our way of create new creative works, how we share them, how we communicate them, and so it has a really strong effect with reference to this kind of very important rights and legal tools also in a way. Also, if you take into account that this legal tool copyright, that's my paradigmatic example, was shaped around a specific technology, so book, so movable type printing, so 15th century, and this kind of legal tool, legal arsenal, is now used for managing and governing a very deeply technological scenario, really changed technological scenario. That's why we are facing problems from this perspective. And of course, the European Union has to embrace this revolution, digital revolution, as to foster this revolution, trying to inspire the main principles we want to. Of course, this kind of chapter and arguments and topics were, when I was writing actually, we were also dealing with the digital single market strategy. So a big main strategy of the European Union in order to break down possible regulatory barriers with reference to the digital market. And several tools, several actions were planned with reference to data protection, with reference to geo-blocking, with reference to updating the copyright system. Actually, when I was writing the chapter, the process was on, and so there were some debates with reference to the main issues that have to be taken into account. And so I was trying to pinpoint the main aspect, the main criticalities. Finally, on April 2019, we had the directive, actually after the finalization of the book and the chapter, our directive that raised a lot of criticism by commentators and scholars. Of course, I mean, my approach again was to analyze legal and factual barriers with reference to this paradigmatic field. In a way, it's really interesting because you have a lot of legal barriers if you take into account the harmonization of possible exceptions to copyright, but also factual barrier, and in particular with reference to this context, technological barrier that really affect the way you may exercise your right. So that's the main idea of my work. Going on, otherwise it's going to be becoming autoreferential presentation. Part 3, dedicated to hindrances or obstacles deriving from economic and monetary crisis. And here we have the chapter of Vasilis Athopoulos who's going to present this chapter, but also from Maribel González Pascual, Raúl Ignacio Rodríguez Magdaleno, Irma Martínez Garcías, and Silvia Gomez Anson. From an economic point of view, these colleagues, these friends, were coming from the Faculty of Economics from Oviedo. And then the last part of the book, dealing with a very interesting issue, the plurilingualism. And Elisabetta already presented a bit this kind of approach, but we will have the presentation of Professor Elena Ioriatti, and we had also a chapter of Margarita Argeles Vélez and Carmen Benavides González, Silvia Adamo again, Céline Lageau dealing with the French system, and Elisabetta Pulice that had written a chapter within this part. I guess that Elisabetta could say some words with reference to the chapter.
Yes, thank you, Paolo. And rather than going into detail of my chapter, I would like to use my chapter to stress some points that are common to the war sections, because what I tried to do was to reflect on the reason justifying a linguistic requirement in the light, of course, of the difference between factual and legal barriers, starting from, as I told you before, the various roles that language may perform, and analyzing some specific case studies, mainly based on the research carried out within the BU Citizen project. And on the one hand, I try to show how hindrances to economic rights can result from linguistic diversity, from the and from the linguistic richness, thank you, of the European Union. But on the other hand, I also try to reflect on how to better exploit the European Union's linguistic richness while mitigating those barriers. And indeed, the relationship between obstacles and safeguards is another perspective from which to address the issue of whether and how linguistic barriers can be mitigated or overcome. And because linguistic barriers have at least double nature, because hindrances to the exercise of a given EU citizenship rights can derive from the imposition of linguistic requirements, from translations and language skills, of course, but on the other hand, hindrances to the other rights can derive from a lack of these elements. And so this is mainly due to the fact that linguistic requirements, linguistic barriers, are usually based on the need to protect a given fundamental right or a specific public interest. And this is the reason why they require an ongoing balance between conflicting rights and values. And in this context, together with, as I mentioned before, the specific case of linguistic requirements imposed upon health professionals, and so the balance between the economic rights of professionals on the one hand and the protection of fundamental rights, of the rights to health of the patients, for instance, I also analyzed education as a tool fostering integration and plurilingualism in the EU, as a possible tool to mitigate, to address these barriers. So, thank you.
Yeah. So I forgot to tell you, at least it's clear enough, who are the editors or co-editors of this book. So sorry for that. But yeah, of course, Professor De Vries, Elena Iuriatti, Elisabetta Pulice, and me. Again, I'm not going actually to waste your time anymore, and so I leave the floor to Anna for presenting the presentation of the two chapters of this book. Thank you again.
Thank you so much. One of my missions is not to use too much time, so I'll be very quick. But having read the books, both the books, I have two remarks, perhaps. I think that one of the richness of the content of the book is to stress and underline very often that there is a strict relationship between hard law, so to say, and case law. And case law is one of the most important elements of your analysis in all the chapters, I think. The other one, perhaps first, in the first session, somebody talked about boxes which shouldn't be seen as separated ones. I think this is another possible result of your research, because there are many different ways how economic rights, which are perhaps the origin of the EU law, influence and keep on influencing also in the present and perhaps in the further future the other kinds of rights, the civil rights. I think, for instance, the right to access culture. The right to access culture is deeply influenced, for instance, by the problems of, technological legitimacy and the lack of technological legitimacy of citizens. And there is a strict link between what is concerned with civil rights in a strict sense and what is concerned with economic ones from the other side. And this is an important result of the books, in my opinion. But now I shut up, and I immediately leave the floor to our next speaker, who is Professor Vassilis Satsopoulos, coming from Greece, and precisely from the University of Athens and College of Europe, who is Professor of EU Law and Policies. Thank you so much. The floor is yours.
Right. So I'm very happy to be here this afternoon. I would want to start by thanking everybody for having me here and all these things. I have to say that this project was an amazing one, not only because we thought and wrote about citizenship, but because we lived citizenship, because we became very close friends with Elena, with Sibe, and with all the other people, with Paolo and all these other people. So it was a real life experience. So thank you again for that. I'm also in the very pleasant position not to have to just present my own chapter, so not other people's work. And to some extent, you'll find that my chapter here offers an alternative narrative to what Catherine explained before, because I will present here a narrative which was likely to lead to Grexit. And you know that Grexit was on the table long before Brexit. We were the first ones to introduce such ideas, like democracy, tragedy, and all these things. And my argument here is that Grexit, or for that matter, Italexit, or any of the southern countries which have suffered from the crisis, if exit is to be discussed, it's not because of citizenship, it's because of the fact that citizenship has failed to deliver all that it has promised. So let me start from the start. Citizenship, European. So one thing about my title. I started writing about economic crisis and European citizenship, and I thought that it was depleted by the crisis. I will explain that. But while writing, I also found out that national citizenships were also depleted by the crisis. So it's not that it's a lose-lose scenario, the one I'm describing. Let me explain why. As Judge DiPreti said, national citizenship and European citizenship are in principle complementary, because in order to have the European, you need the national. Okay, but in many respects, these two citizenships may also be antagonistic. And people have written about so-called cities intruders, so nationals from one member state who go in another member state and try to benefit from the social and other rights there offered. And also other people have written about so-called egoistic free riders. I'm referring to people like Mrs. Vats being a British national who wanted to bypass the long waiting lists in the UK and went to France to have her hip surgery, or Mrs. Petru, a Romanian national who didn't like how the hospitals smelled and felt in Romania and went to another country and then had her own welfare system pay for that. So there are, these two people are people who went to another member state in order to benefit there from citizenship rights, while, as Catherine said, while having the local taxpayers paying for that. Okay, so in principle, the two citizenships are complementary, but there may be antagonism between national citizenship and European citizenship, who goes and when people go under the European citizenship, go and claim benefits that normally would be only limited to nationals, to people having national citizenship. Now, Catherine was quite clear on that Brexit was, to a large extent, due to immigration and to social rights. And, of course, Brexit is the absolute denial of European citizenship in order to safeguard national citizenship. And, of course, again, I'm referring to Catherine, she explained that in terms of identity, and we said that it's a chicken and egg question, but nonetheless, What I want to focus to the other member states which are not exiting right now, and say that in these countries the crisis has made both EU and national citizenships suffer. Like Catherine, I'm following the T.H. Marshall definition of citizenship, having three kinds of rights: civil, political, and social. So I will in turn look into these three rights. First of all, civil rights. Civil rights are connected to individual freedom and to economic freedom and to these kinds of rights. And these, in principle, are favored by the European Union and by European citizenship. The European Union is about free market, is about entrepreneurship, is about people empowering people to go where jobs are, and so on. And like texts like the Services Directive have done a lot to help people substantiate such rights. And then also other instruments that crisis hit countries have had to deal with, like the OECD toolkit and the World Bank's technical assistance, also go in this direction of favoring economic freedom and individual rights. And this, the result of this, of applying these texts or documents or instruments, was to open up closed professions and to have less authorization and less red tape and less rent seeking and more individual freedom. So apparently, on that front, on the civil rights front, the European Union and its citizenship are a good thing. However, and the crisis to some extent is a good thing because it requires structural reform which empowers individual freedoms. But most of these structural reforms, at least in crisis-laden countries, come together with fiscal measures. And like on this slide, I've put some data from Greece, but I have in other slides I have data from also other like southern or periphery member states. So in the 8 years between 2008 and 2016, in Greece you had available income and pensions reduced by almost 30%, funding for education and research which was reduced by 35%, health expenses by 40%, and unemployment went up to skyrocketing at some point for young unemployment to 58.3%. So more than 1 out of 2 young people were unemployed. Okay, so it's all very good to have the right to start a business very easily without red tape and without too many authorizations. But if this business is not going to last, your freedom is quite theoretical. And actually, crisis created an even bigger divide between the southern countries and the northern countries, which is another problem for citizenship and belonging together. Because how would you may remember, we in Greece do remember that at some point our worst enemies were the Germans, because they thought that they were very bad and lazy people, and we thought they are Nazis and things like that. And this didn't go too well with identity and citizenship. Okay. And then we have people like from Greece, Italy, and other countries leaving to Germany, the UK, and so on, where they are scapegoated because they are the bad guys trying to get benefits. Even if they are bright, they have good studies, they count as brain drain for the countries they leave. They count as bad people and scapegoats for the countries they go to. And this scapegoating has been, as Catherine mentioned earlier, has been recognized. I see it in a different perspective, of course, from Catherine. It has been also mirrored in the court case law, because as Catherine said, although we had some early cases like Zambrano, McCarthy, Derez, and so on, which are very expansive and very helpful and very in favor of EU citizens, then in the years 2014 and onwards, starting with Dano and other cases, there is a retreat. And this retreat is important in many ways, not least because some authors have very early on identified a big like a hiatus or a difference between the economic competencies of the EU and the social competencies, and had found that the economic ones are much more important, and then thus there's a liberalizing, ultra-liberal effect and so on. And some people, including myself, thought that yes, but the court, through the citizenship instrument or tool, is nonetheless trying to bring the social agenda into the image. And I think that Daria again talked about dialogues between national courts and Luxembourg, and I think that in this dialogue the ECJ had done quite a lot to enhance or to push forward the so-called European social model. And then the entry into force of the Lisbon Treaty, which has the Charter and has a stronger legal basis for social matters and so on, people thought that, this is it, we're getting there. And then, of course, with these judgments, the court reversed the trend, and actually Catherine, in an article of hers in 2017, the title was "The Day the Clock Stopped." So this process of socializing the EU was reversed. Okay, now let me turn to political rights. Political rights, we have to distinguish between member states which has gone through crisis, troika, memoranda of understandings, and so on, and the normal countries. Let me start from the abnormal countries, my own first. Okay, you may remember that the big problem that the EU faced when it had to deal with Greece, Ireland, Portugal, was, in legal terms, was Article 125 of the treaty, the no bailout clause. So in this provision, which is still there, it is clearly stipulated that member states cannot bail out other member states. Right. So when Greece had to be bailed out, it was deemed necessary to bring in the IMF, International Monetary Fund. Okay. The IMF, however, operates on the basis of the so-called conditional loans. Conditional loans, or in EU parlance, the principle of conditionality. This means that we give you money as long as you do what we tell you. Okay, and conditionality is something that the EU itself has been using, but towards third countries, towards countries of the European neighborhood policy or other countries where it offers capacity building and so on. And it's a means or a principle which is completely contrary against, or runs completely on the face of the principle of mutual trust, which is what the EU is being based on. The principle of mutual trust is the basis, the cornerstone of the principle of mutual recognition. All the internal market is based on the principle of mutual recognition. So by bringing in the principle of conditionality, a cornerstone of the European construct is being put to question. But then, most important for my presentation here, we have some member states which are compelled in ways much more drastic than the EU construct foresees to do things they haven't chosen to. Okay. And so the IMF measures very often, because the IMF has the objective of convincing banks to give loans to countries. So basically, to a large extent, the IMF imposes measures wanted by the banks or by the credit rating agencies, which are not necessarily the best measures for the countries involved. They are good for banks, but not for the people. And so another thing about the IMF is that it's it's a global institution. It has 189 countries, and the biggest single player is the US with 16.7 of votes. And then you see that all the big European countries have much less, and small countries are completely invisible. Okay, so their interests are not very much taken into account. So that is for the IMF. The second part of the Troika is the ECB, the European Central Bank, which is independent and politically unaccountable. And also, we can see also judicially unaccountable, because in every occasion where a decision of the ECB has been brought before the Court of Justice, the Court of Justice has given it the green light, even if it was striking how, what the ECB was doing was against the treaties. And so, an important part of the thing about the ECB is that when its chair, governor, president, Super Mario, said that we will do whatever it takes to save the euro. Whatever it takes meant many things. Among other things, the outright money transactions, so buying state government bonds at the secondary markets, but which the ECB did when the country is concerned, fulfilled the conditions that the ECB itself was putting to them. So the ECB has not been just a monetary actor, but also an economic policy actor. Okay. All the same being unaccountable, of course. Non-elected, non-controlled, and non-political.
Let's try.
Okay. So, and the third member is the Commission. Okay. Just one last word. Nowadays, we wouldn't have the Troika. We would have the European, the European Stability Mechanism, which is a purely intergovernmental body. Okay, so it's outside the rules, the checks and balances of the EU. Now, this goes for member states in crisis. Member states, all the other member states, nowadays, under the six-pack, two-pack, and the so-called European semester, they have their budgets discussed by everybody else, like by other member states, by the Commission, the budgets have to incorporate this principle of the golden standard, so of maximum 0.5 structural deficit, and this is again, these rules are implemented by the national budgetary discipline authorities, which are technocratic, of course, their network at the EU level, and they are overlooked by the Commission and the Court of Justice of the European Union, which may impose fines. So, to sum up with political rights, what I would say is that both in crisis and normal member states, core political choices are dictated, applied, and supervised by technocratic, non-elected, non-representative, non-accountable bodies. Okay. This means that if you believe that there needs to be a change, it's not by voting for a normal opposition party that you will have change. If you really need change, you are going to vote for Syriza, Golden Dawn, Mélenchon, Farage, Salvini, because these are the guys who pretend they can deliver. All the others are bound by the system. Okay, so the fact that we have these populist, Eurosceptic parties is to a large extent connected to the fact that core decisions are not taken by accountable bodies. And in this respect, Grexit, Italexit, or whatever, may look as a guarantee for democracy, actually, because it brings back the power to elected and accountable bodies. And here, let me introduce this idea which was expressed by Yuka Snell, himself being inspired by some other people. So he says that we cannot have at the same time these three things happening together. So we cannot have participatory democracy, national sovereignty, and a fully operational European and monetary union. And what he says is that first, before the crisis, we had participatory democracy and national sovereignty, but the EMU was problematic. Under the crisis, we fixed the EMU in an intergovernmental way, so still national sovereignty was there. But what we need to do here now is to have operational EMU with participatory democracy at the EU level. And this is why, according to him, to myself, we need more deepening at the level of monetary union. Now, very briefly, 2 minutes, thank you, for social rights. So what happens with these structural reforms I mentioned earlier is that they really question, because structural reforms are much more difficult than budgetary fiscal reforms. Like, if you want, this happened in Portugal, on the same day you introduce like very important cuts on health expenditure, and you introduce the system of electronic prescriptions. Electronic prescriptions are going to save money once they're implemented in 3 years' time. But if in the meantime you start at the same time with electronic prescriptions which will be effective in 3 years' time, electronic prescriptions is a way to save money out of drugs and medicines, okay? But it takes time to implement that. But if you start at the same time like trying to implement that, which will be effective in 3 years' time, and at the same time cutting all the money that this will save in 3 years' time, you are heading to a disaster because you have less money and not the prescription right, the savings right away. So this trend can be identified in many levels, like at an inequality level. We have like population below poverty line in Greece is 40%, but if you see here, like the social injustice or justice index for 2015, Greece was 28, Italy was 25, Spain was 23, Portugal was 20, Ireland was 18 out of 28, of course. Huh? So you see all these countries have been at the very bottom line. Healthcare has been suffering because there has been facilities closed, treatments excluded, and increased needs because of psychological reasons, nutritional problems, and so on. And unemployment has been extremely high, and you see that from this study from Eurostat, which says that from the PIGS, so the Portugal, Italy, Greece, and Spain, out of the people leaving the country, you have 88% having bachelors, 50% masters, and almost 12% having their PhDs, and then they go away. And then the worst part is that even for people who do have an employment, their employment is not enough for them to live. So they are still under the poverty line. So all this together questions fundamentally the existence of the welfare state as we know it. And what happens is that the EU questions the welfare state, the national welfare state, without itself offering an alternative. So my conclusion is that there has always been a disequilibrium between the economic and the social in the EU. It was on its way of being compensated with the court's judgments on citizenship and with the Lisbon Treaty. Then the crisis came and it got really bad. And the crisis made output legitimacy, to use Gian Domenico Magione's words, much less. So it reduced output legitimacy. And the reply to that, what the EU did is that we reduced also the input legitimacy. Because instead of having elected, accountable bodies deciding, we had all the technocratic, non-elected, non-accountable bodies. Participation in the EU and EU citizenship is more of a disadvantage than it is an advantage. And this explains, again, the Brexit and all this populist rise in Euroscepticism in member states. Under these conditions, the European citizenship looks as being unwanted, and exit looks as a guarantee of democracy. Or the alternative is to have a deeper EMU and a deeper citizenship. And on this I refer to what the Daria, I think, said, that citizenship is variable, it may vary over time, so it may have more or less rights, and the idea would be to bring more rights, in principle social rights, within citizenship at the EU level in order to compensate for the losses that I have explained. Thank you very much.
Thank you so much. Very, very, very interesting and not too long. So really thanks. I think that a possible message is also that European citizenship could also be sometimes, hopefully seldom, a bit counterproductive. There is also a dark side of the moon, I mean, from this point of view, because the starting point is a principle of equality, which is especially a principle of formal equality, while instead the starting point in the different member states is quite different from one another, and this could be perhaps kept more deeply in mind by the European legislators and policymakers. Anyway, now the floor is back to Elena Iodiatti for her presentation. Thank you so much.
Thank you, Anna. So when we started, where we involved as Trento team in the BU Citizen project, the issue of the language was not there. But then, as this was an interdisciplinary project, then we started to discuss with the colleague, because we had political scientists involved, economists, expert in social sciences, and then it comes up very gradually that the language issues was an issue. And so CIBE was flexible enough to let us start a specific field of research on the language barriers. And and in fact, in the last book, summarizing all the results of all the projects, so this is the 8th book, there is a chapter on the language barriers. But the reason why I'm here is, unluckily, because all the other colleagues were not available, because we have very interesting chapter in the book on economic right. One chapter was written by the colleague from Oviedo, who are expert in economy, and they studied the economic cost of plurilingualism. That was a very interesting issue. Then Silvia Adamo, an Italian colleague, she's associate professor in Denmark. She explained, she put forward the example of Denmark. There is a legal system in which the English knowledge is kept so high that it prevents the circulation of workers from outside Denmark. And then Céline Lageau, she explained that, for example, in France, the very well-known loi Toubon, that is protecting the French language, is preventing the other European language to play a role in France in some specific field, like, for example, in the field of consumer protection. So all these were very interesting issues related to the language barriers. And in my case, I will summarize very briefly what I wrote in the book. My point was that in order to be effective, the right, the citizens' right, have to be properly implemented in the member state. And of course, the rights, as they are also contained in the writing and regulation, have to be interpreted and applied in the member state. And sometimes the point is that this does not happen properly because of the language, because the EU is creating a new language of the law. And this is particularly true for economic rights, and Anna correctly said the economic rights were the original right. And so indirectly they shape the legal language of the European Union. Because at the very beginning, the terminology of the European Union was not legal terminology, but it was an economic terminology. If you think, for example, of words like circulation of persons, services, competition, capitals, you immediately realize that those are not the typical category that you find in the member state, but they are very specific. And so this specific terminology then was transposed into the secondary law, so the writing and regulation, and it shaped the legal language of the member state. And so this legal language of the European Union is written in a very peculiar and specific way. So there is no sort of legal culture behind it, like we have in the member state. In Italy, for example, my students know that the civil code was based on the French and on the German culture, but this is not the case of the European Union, because the term and the rules are invented by nothing every day. So there is not a legal culture and a legal terminology behind. So these words are fundamentally neologism. They are very new, and when they arrive in the member state, it is quite a challenge for the jurist and the judge in the court to give it well, the proper interpretation. And then the Court of Justice has invented a very clever strategy, because the message of the Court of Justice is that all language versions are equally authentic. So the message to the justice in the member state, to the judge, is that you have to find out the meaning by relying on all the different language versions. That is a very clever strategy, but of course it is a strategy, because this one, from one side, is apparently keep reassuring the European law drafter, because they draft, and when they have a doubt, they say, okay, but there is the Court of Justice, and the Court of Justice say that we don't have, even if we have difficulties in finding the right word, then we will have the other languages. But then the problem is that in the university, we are realizing that there is something wrong going on, because sometimes we are considered a sort of emergency rooms, and we sometimes receive phone calls from translator or jurislinguists or judges asking for an advice about a term. But of course, it is not our task. And so what I think is that perhaps we should reflect on a sort of theory, and particularly what is lacking from my point of view is not the fact that the judge do not understand the term or do they not find a solution, because they do. We have decision in Italy and around Europe in which it is clear that the judge give the proper interpretation of the term, and they know how to do their job. But the problem is that they do that in isolation, in a sort of solitude. So one solution reached in Italy, it is not spread around Europe. And furthermore, there is no a sort of hermeneutical theory of the interpretation of EU law. Because of course we have the criteria of the Court of Justice, but for example, we are not connected with the EU law scholars. Who, of course, they do rely on the criteria, but sometimes they do not take into account the language. And with us, we study the language, but we are not connected with we haven't got the support of the expert in EU law. And so, and that's even if in EU law there are some theory coming up, according to them, the European Union is a sort of shared system of rules. It's a sort of polycentric system of norm in which not only the national legislator, but also the judges are contributing to the creation of the EU legal language and on the interpretation in the member state. So, from a comparative point of view, we have elaborated a sort of theory according to which the words of the European Union are sort of linguistic sign. So they are sort of boxes, which are not, of course, final, they are not exhausted, but they have to be completed by the interpretation of the court in the member state. So we call them meta concept. It working like the term containing legislation in the UK, for example. You know that as a student, we learned that together, that in England, traditionally, when a statute is enacted, it is not final until it is not applied by the court. So here the situation is more or less the same. The terms are there, but they're not final, and they have to be completed by the interpretation by the court. And of course, I'm not going through this, but I'm working on a sort of model that demonstrates that when the terms of the European Union are reconnected with the national interpretation, or also with the national statute, for example, enforcing EU directive, then the real meaning of EU law is much more clear. It's final in the end. And this is also important because if we look simply at the legislation in the member state and we rely on the term that contain in statute, for example, we forget what is really going on a practical level, the so-called operational rules. And I give you an example. In France, the real rights that are very relevant, for example, because of the succession regulation of 2012, the word real right is really relevant for the application of the succession regulation. But if we rely on the word real right in France, in the civil code, we have a certain number of real rights that are typical, like in Italy. But then, in case law, new real rights are being invented. For example, in a quite recent decision, the so-called Maison de la Poésie of 2012, there is a new real right. That is the right of enjoyment and occupation of a part of immovable property with no time limit. So, in order to fill up the meaning of the right at the European level, I think it is important to take into account the court interpretation and what, as a comparative lawyer, we qualified as the national format. Okay, so this is more or less the content of my chapter, and I thank you very much for your attention, and I give the word to Anna again. Thank you.
Just to say that this is very interesting as well, Elena, and I think that perhaps a final conclusion, but it is not final, of course, could be that this kind of phenomenon at the supranational law is going to transform the meaning of technical legal terms, perhaps not adding new meanings, but moving the boundaries. So what is really changing is not the original meaning, but the boundary of the original meaning, and perhaps this makes legal terms much more flexible, as we told before, talking about the concept of citizenship, of course, which is perhaps also an example of this phenomenon. I think that we can stop here our session and we can enjoy our deserved break, 15 minutes, okay? And then we come back here for the other session. Thank you so much. Welcome back. Here we are for the other session, and I'm very happy to chair it too, of course. Now, the subject of our interest is the civil rights in the perspective of European citizenship. It should be, at least. Let's see what happens. And our first speaker is Professor Henri de Duvalle. Great, I've learned how to pronounce exactly more or less his surname. And I think the best thing to do is to leave him immediately the floor. He will introduce himself more briefly. Thank you so much.
Molto grazie, Professor Simonati. Also thanks to Professor Giuriati and all other colleagues here. Dear colleagues and friends, indeed. Dear students, present as well, still hanging in some way, one way or the other. The whole BU citizen experience has been one long journey, and perhaps comparable to the Odyssey of Homer, or the travels of Aeneas, all the way from the burning city of Troy to the pleasant lands of Italy, as recounted by Virgil. But if that is the case, then how might we label the stage that resulted in the publication of the Civil Rights volume? I won't compare it to the travails of Odysseus or Ulysses in the land of Cyclops. Perhaps, however, we could draw some analogy with Ulysses' perilous trip when he tried to circumnavigate a passage around Scylla and Charybdis. And, well, in that metaphor, in the EU, maybe the rule of law crisis in the EU being the monster on the one side, and maybe Brexit and its fallout, the monster on the other side. Both of these developments have had a clear impact on rights of citizens and on their civil rights in particular. But if you see also the cover of the book as such, and if you know a bit also about both concepts, you might wonder, what is the linking pin or what is the thread of Ariadne between civil rights and EU citizenship as such. Citizenship itself, we could conceive of it, in the words of at least one famous dead white male, as the mystical relationship between the person and the state. Another towering figure, Thomas Jefferson, defined civil rights as human rights for citizens. And as many of you here know, with that definition, Jefferson obviously and notoriously, he had in mind rights for educated Caucasian men like himself, probably not even women, and certainly not otherwise colored members of humankind. The take of Jefferson is clearly worlds apart from that of the ICCPR, the International Covenant on Civil Political Rights, only much later, because ICCPR talks about civil rights and says civil rights is something predicated on personhood, so not so much on citizenship. So that doesn't provide a real connect either. We can take a more linguistic or semantic approach, and then we should perhaps be reminded, as page 1 of our book in fact actually does, that the concept of civil rights is literally derived from the Latin jus civis, referring to the rights of the citizen. And then we get to an answer. Consequently, somewhat surprisingly perhaps, all citizenship rights were originally civil rights. And I'm sure most of us here will agree that all civil rights nowadays are citizenship rights. I think few may approve of the reverse, that all citizenship rights are, per definition, civil rights. But that's nevertheless what I would dare to posit. Even when certain of those rights are effectuated in the socio-economic sphere, as we've also just heard, still I think it's a contention which holds. I think the argument is even more readily digestible when we think of political rights. Political rights were classically, of course, already incorporated under the concept of civil rights. So again, civil rights being the wider, overarching notion. If we pursue this trail of thought further, then of course this nice volume could have been overarching in itself. Perhaps this could have been the main volume in the whole series, interconnecting all the different volumes. And I think in a way, the book also lives up to that promise by actually not leaving aside the socio-economic rights, nor the political dimension. We have chapters on residence rights. We have a chapter on civil society organizations. So in that sense, actually, this is more of the umbrella or maybe the master key to even the whole project. And Siba realized the thought is a little bit heretical compared to the original BU Citizen FP7 application. But well, the project is being completed anyway. And I dare to presume there's no one from the European Commission listening in here today. Yuri Borgman, not available, at least not right now. Okay, maybe stuck on a train somewhere in Innsbruck. But well, so arguably, the idea to separate the civil, the economic and the political, and to place them in distinct work packages, maybe was to a considerable extent artificial. And consequently, the placing into boxes, or placing into silos of the civil, the socio-economic and the political, was perhaps not justified, at least not historically, not etymologically, and arguably even legally. With apologies to T.H. Marshall, apologies to Catherine Barnard, Kia Signomi, Ya Vasili in Greek, because also I think it explodes in a way his brilliant expose which we just heard. So we can collapse maybe that threefold distinction, because it doesn't hold up ultimately. Now, all this by way of introduction, it strays a bit from the rather more humble and much less unorthodox introductory chapter. Marie-Pierre Ranger and I wrote in the introductory chapter, one cannot engage in an examination or an appraisal of the concept and practice of EU citizenship and of the barriers without a thorough investigation of the civil rights that are associated with it. So we then simply say it is an association. Now, what do we try to do with this volume? Now, it attempts to demonstrate that this concept of EU citizens, EU citizenship, it has opened up new opportunities for the protection of civil rights in areas subject to European regulation. But not just that, opportunities also, in some circumstances, in the civil sphere, even in matters which have largely remained within national competences. As many here know, whenever the situation of a citizen falls within the scope of EU law, then union citizens, and occasionally also other others resident on European territory, they can invoke supranational standards of civil rights protection when national legal systems fall short. Where national legal systems fall short, think, for example, of the right to respect for privacy, the right to have a proper respect for family life, not even connected to the EU national as such. Now, I think the novel take of our volume is that you do have these kind of studies from public law scholars, but they tend to approach that thematique a bit from a comparative constitutional rights perspective. You have international human rights lawyers which also look at this subject matter, but more in an instrumental way, looking at the international instruments which ensure the minimum protection for civil rights. Plenty of EU lawyers writing on this, but more on the union share in the development of equality norms or the free movement of persons. So at least in that respect, in contrast, maybe this book offers a slightly different and more original perspective. Original because, first of all, it was not possible, of course, to cover every aspect of the spectrum, but we aimed to highlight the relevance of EU citizenship for the protection of civil rights across all kind of different levels and all kind of different layers where it has made its presence felt. So in contrast to the more unidimensional approach of other legal disciplines. Secondly, the book seeks to explore the manner in which the protection of civil rights either helps to redefine or at least urges to redefine the notion of citizenship beyond the state. And last but not least, and not surprisingly, the book should assist in pinpointing barriers to the exercise of civil rights by EU citizens, and there especially at the national level, so that they can be tackled and gradually eradicated. Now, all this sounds woefully pretentious, and if all of this sounds woefully pretentious, that's entirely logical. It is all rather pretentious. Even removing of obstacles, hoping that this volume also would there play a particular role. Well, Marie-Pierre and I, we were obviously not banking on it either, that either Mr. Kaczynski or Mr. Orbán, or Mr. Johnson for that matter, that they've already taken out a subscription to the EU Citizen book series, unfortunately, to their disadvantage, obviously. The subtitle of the book, which some of you may have spotted, it indicates explicitly that the chosen approach specifically adheres to three main nodes, and those nodes highlight challenges which originate from respectively the European, the national and the private sphere, and in alternation, each of the chapters places emphasis on one or more of those nodes. Let me highlight some findings from the book. Well, as it makes clear, the existence of citizenship raises numerous new challenges, and it points to the fact that you might have all kinds of interesting actions and instruments in the supranational sphere of governance, but these might actually even turn out to pose threats. And that's something which Vasily also has highlighted. Take the austerity measures adopted during the Eurozone crisis since 2008. And there actually you see also actually at the supranational level, EU citizens being affected, not positively, but rather more negatively. And if you then look at the civil rights, which we also sketch in our book, well, look at freedom of assembly, look at the right to protest of citizens placed under EU supervision and strict conditionality regimes, indeed that kind of depletion which was already highlighted before, and maybe not mentioned in the previous presentation in a number of countries. Those measures also appear to have dented the protection of the right to property. So it even goes so far in civil rights terminology. Look elsewhere at cooperation mechanisms such as the European arrest warrant. Again, a positive measure, that's a way to look at it, but also as elucidated in the book, the right to a fair trial of those accused of crimes. Well, those people who are being chased and mopped up maybe a bit too early, too easily across borders, well then in that sense the European arrest warrant actually places considerable strain on civil rights rather than being such a helpful tool. Take other EU anti-terrorism measures, in say driven by perfectly valid security concerns, but sometimes leading to wide-ranging intrusions into citizen privacy and severe restrictions to their freedom of movement. So, clear finding here also the nexus between EU citizenship and civil rights is definitely not all rosy, but displays darker sides as well. The arrival of the Charter of Fundamental Rights just 10 years ago might prima facie seem to constitute a very healthy and a very welcome development. But for lawyers, it has sparked already many further technical puzzles. Because the scope of the application of the Charter initially seemed relatively narrow, and initially even perhaps a retreat from the rather generous ERT approach, but then enter Ackerberg-Franson, the judgment and its progeny, and you see there also that suddenly a widening occurred, but what type of widening was yet to be further clarified. Daniel Sarmiento has recently argued that a few recent rulings signal an unhelpful retreat. I'm not entirely sure it's the proper way to interpret the verdict of the Grand Chamber in the Finnish TSN case. That outcome still seems rather logical in the context of the harmonization technique employed in the directive concerned, but Sarmiento may well be right, and Elena Francius made a similar point. The member states concerned, Finland, was patently acting within the scope of EU law, and that ought to have triggered the Charter's application in full. But, well, here's another little puzzle which is yet to be resolved. Now, this is a bit in too much detail, maybe. Further dimension, actually, of a related nature, but also of broader resonance. And I think this links back also to the presentation of Catherine before. Charlotte O'Brien put it like this, that the court with EU citizenship dared to play politics, and ultimately the court lost. And then look at Dano, look at Alimanovic, look at Garcia Nieto. You have all those kind of limitations on the rights of inactive citizens. The court thought it was doing the right thing with that kind of backtracking. The 2016 Commission v UK case, maybe the pinnacle of its pro-sovereignty stance. Well, there again also banking on it that in that way it would make a difference, but as said, already too little, too late, a ruling causing reputational damage for the court, eroding the consistency of the case law, and as such maybe leaving the civil rights of residents and equality alive for some, but not exactly kicking. Compare Poland, compare Hungary, to a more limited extent maybe also Romania, Bulgaria, Slovakia, Malta, the Czech Republic. Other civil rights there may well be struggling, perhaps even on life support as we speak. What kind of tools there are deployed for enforcement? Well, infringement procedures, which may go somewhere, as we know from the Polish case and the Bielowica forest, but whether the rather more powerful Article 7, as also here kind of a master key in the guaranteeing of civil rights, whether that will ever see a potential application remains to be seen. So what is the best way forward for the Commission, for the courts, for other political institutions? Well, their volume has more of a to be continued kind of ring. It doesn't offer really clear-cut insights here, but, well, there are alternative studies abound which specifically deal with that theme. What do most of the studies helpfully do, or we would dare think, in this volume? Well, I think this volume does manage to forcefully underline that the effectiveness of the rights of EU citizens is highly contingent on implementation at the national level. So again, perhaps also beyond the constitutionalist bubble, beyond also there the supranational interaction indeed. So here, contingent on implementation at the national level, whether you talk about free movement and residence, whether you talk about protection of personal data, recognition of life events, as nicely explored by our colleagues from Oviedo, digital journalism, which Silvia Adamo plunged into. I think you have multiple authors in the book which neatly identify how you can have, at the domestic level, a less than smooth reception. And what that actually might well do is actually jeopardize all that is conferred by union law. So then whatever you have in terms of niceties at the supranational level, they're also without the proper connect, actually all might well be lost almost instantly. And also the book already testifies to the fact that indeed with regard to bottom-up engagement with EU civil rights, actually the national efforts can be and should be significantly greater. Let me, by way of conclusion, just mention one dimension of that issue here, and that's also pointed out in the concluding chapter, namely that the European Commission could more overtly insist that member states refrain from playing that eternal Brussels blame game. So there's a clear role for the Commission here, which is yet to be taken up more forcefully. Juncker didn't do it, at least not enough, and well, Ms. von der Leyen has her work cut out. So the Commission should remind the member states more emphatically of their own responsibility in the eradication of barriers. And then it's all about encouraging action at the most appropriate level and as closely as possible to the citizen. But that's indeed also here member state action, and also here, of course, the supranational cannot do it itself. I think in terms of philosophy, in terms of ideology, in terms of well, the programmatic approach which you will need to sell in this world full of PR and propaganda and framing and spinning. The nice thing here is if you do this, then of course it's a highly original reference to that also treasured principle of subsidiarity. And well, back from the past, from the whole Maastricht era, subsidiarity may, perhaps yet again, be said to become ever more important soon, but then actually placed in that key, also here to make clear that through subsidiarity also here, loyalty is due, where right now actually also here the reverse takes place, and also here Brussels is placed at the center as the fons et origo of all that is nasty and also impinging upon civil rights, but rather the reverse might be true. Now, this very talk, of course, risks to infringe the principle of subsidiarity because I'm not deferring enough to the actual contributors to the volume, and that's why I'm happy to leave it there. Thank you very much.
Thank you so much. We can see, therefore, a very fragmented and complex and complicated scenario, I think. And having read the book, I also can add that perhaps a common point in all the very numerous and various and different legal systems which have been analyzed is perhaps, and of course I am talking from the point of view of administrative law, the importance, the common importance of procedures, because sometimes the protection of civil rights is not granted only by substantial rules, so to say, but procedure have a really important and primary role in these. That's my point. I don't know if you agree. You do. Great. Thanks. So let's leave the floor to our next speaker. I know that I'm not using the right pronunciation, but she generously allowed me to read her name like this, Dr. Hanneke van Eycken. Oh, great. I've studied during all the break. Yeah. But now she will pronounce by her own perfectly her name, and I leave her the floor. Thank you so much.
Thank you very much. It's a real pleasure to be here. It's also a bit sad because actually yesterday on the train ride to here, I had plenty of time to make this slide, and I put on the logo of BU Citizen, and I feel very proud but also sad because this will probably be one of the last presentations of me with that logo on it. So that's already a kind of a incentive maybe to think about the future of BU Citizen. I would like to talk today on nationality and EU citizenship. So I wrote together with Pauline Poa, who was not able to be here, a chapter on core rights of European citizens. And actually the most core right, you could say, is the right to a nationality. So if you don't have the nationality of one of the member states, you're not an EU citizen. So then social rights do not apply, equal treatment doesn't apply, or it applies actually in another way. So therefore, we defined actually the right to nationality for EU citizens as a core right. And I was actually very happy with Katrina Bernard this morning talking about the Tindemans report, because I felt yesterday evening actually to include this in my presentation, actually because of the elections in the UK, because if you see that in the Tindemans report in 1975, and it's a long quote, of course, but it's being said, proposals bringing Europe nearer to the citizens, give it its social and human dimension. They attempt to restore to us at union level that element of protection and control of our society which is slipping from the grasp of state authority. So that are very big words, of course. But if you don't have the nationality of one of the member states, then actually you don't have something to keep hold on. So the starting point is Article 20, and I think I can be very short on that. Article 20 says every person holding the nationality of one of the member states is an EU citizen. And there you actually see the problem, because member states are still remain the main gatekeepers to nationality. So it's up not to the European Union to decide who has the nationality of one of the member states. That's up to the member states themselves. And therefore, you can actually ask yourself whether nationality might also be the weakest link of European citizenship. So the chapter in the book has been based on a report I wrote together with my colleague Pauline Poa. We compared a couple of countries in that report, and we looked at, as I said, nationality as a core right of European citizens. And there are basically two things. First of all, the acquisition of nationality, and that's also highly debated at the moment, because as you probably have noticed, on Malta or in Hungary or in Portugal, you can actually buy nationality of the European Union and therefore also European citizenship. So I think that's a very, very main threat to the whole concept. If you're talking about constitutional concepts, then if that's for sale, then the whole thing is going to be eroded by that. And the second challenge is actually the withdrawal of nationality, which I would like to discuss more in this presentation. And with regard to withdrawal of nationality, of course, we have Brexit. I won't discuss that in detail, but of course, British nationals aren't EU citizens anymore after the last day of January in 2020. However, I can imagine actually that the Court of Justice will do something in terms of acquired rights, but they will actually lose their status, not because they lose their nationality, but because the UK is no longer a member state, and therefore they don't fit within Article 20. And then I would like to go back in time, actually, to the case of Rotman. And I don't know if you know that. Do you know that case? No? Okay, I will try to do that in 3 sentences. An Austrian national going to Germany, asking for the German nationality, then his Austrian nationality has been withdrawn because he acquired the German nationality, and the German authorities discovered that he lied, or at least that he was silent on certain things. Then they wanted to withdraw the German nationality because they said he committed fraud during the naturalization procedure. As a fact, then, Mr. Rotman would become stateless, but he wouldn't have European citizenship anymore because, as I said before, European citizenship is based on having the nationality of one of the member states. And that was actually why that case came to the Court of Justice in Luxembourg, asking, does European citizenship actually prevent such a measure that you can revoke the nationality of someone? And actually, most scholars, and also actually the Advocate General in this case, argued, no, because there's no cross-border element, so it's a purely internal situation in one member state. We're talking about the German in Germany, because he lost already his Austrian nationality. And then the court said, the situation of a citizen of the Union who is faced with such a decision falls by reason of its nature and its consequences within the ambit of European Union law. And that was a landmark paragraph. Funny thing is that actually paragraph 42 is famous in the Rotman case, but also in the case that actually followed Rotman, because in the case of Rio Zambrano, the court built on this. So the court said also Article 20 precludes any national measures which have the effect of depriving European citizens of the genuine enjoyment of the substance of their rights. So whereas previous case law of the Court of Justice would focus much more on free movement rights, there was suddenly a shift from Rotman to Rio Zambrano to other cases on Article 20. So even if you do not use your free movement rights, you can actually invoke European Union law. However, the court also said on the Red Sea, for instance, that it's very much limited. So it's limited to those situations in which a European citizen would actually be forced to leave the European Union as a whole. So in order to invoke Article 20, you have to make a statement. This measure, this national measure, forces me actually to live outside the European Union. And that's, of course, a very difficult test. However, for me, it's still a revolution. Why? And it's also because I think it's constitutionally framed rather than market-grounded. And I say that because I do feel that the internal market idea of the free movement idea has been abolished a little bit more. So now also purely internal situations, or what used to be purely internal situations, fall within the scrutiny of the Court of Justice. And what you also see, and that was not in Rotman, but it came in Rio Zambrano and also in Chavez, is that actually family life and the rights of the child are being included in the case law of the Court of Justice. So whereas in previous case law, the Court of Justice would actually say nothing about fundamental rights on European citizenship cases, now you see that the fundamental rights narrative is being invoked in these cases. The case Chavez is also an example of that, but in terms of time, I might be very short on this. It's a Dutch case, actually. It's on a mother with the nationality of a third country and a Dutch father. And in the Netherlands, it's the case that if you recognize a child, it gets the Dutch nationality. So these children were being recognized by a Dutch father. Those fathers moved away. Somehow there was one father, so this is about 8 cases. There's one father that actually lived in Costa Rica, so he didn't see the child. There was one father who just visited his child, I think, twice a year or only on birthdays. So there were very different situations, but actually the fathers weren't present. So the mothers who didn't have the nationality of one of the member states were the primary carers. And then the question was, does the mother have a right to reside in the Netherlands? Because she's taking care of a Dutch child. And the Dutch child is, of course, an EU citizen. And there the court said, yes, and then you have to see whether that child is dependent on the mother. And there comes the fundamental rights in, because then the Court of Justice said, you have to establish whether there's a relationship of dependency between the third country national parent and the child, so in this case the mother and the child. And in order to do that, you have to assess also Article 7 of the Charter of Fundamental Rights and Article 24, paragraph 2 of the Charter. So what you see here is that in the case of Rotman, the Court of Justice did not frame it in terms of fundamental rights. In Rio Zambrano, you do see fundamental rights, but not that obviously. So I remember that after Rio Zambrano, Siebe and I wrote an article like, is family life included in Rio Zambrano? And then the case of the Recci came out, and then the court basically said, family life is not included. And now in Chavez, you see that the court is kind of shifting. So now fundamental rights are actually back into the debate. And then the next stop is the case of Chavez. And Chavez is also a Dutch case. And Chavez is really about European citizenship and nationality law. And I wrote an article, and I called the article Chavez in Wonderland. So I'm sure you're familiar with Alice in Wonderland. And this quote is actually what happened to these people, because what happened in the Chavez case is it's about Dutch people that lived abroad for more than 10 years, and then their Dutch nationality was being withdrawn automatically without any notification. So we're talking about a mother of 2 children who was living in Canada with her Canadese husband. She had the Dutch and the Canadese nationality. And then because she was more than 10 years away, she lost her Dutch nationality. Then she requested for a passport because she wanted to travel back to the Netherlands. And then her passport was being denied because according to the Dutch Passport Act, Article 9 says you can only give someone a passport who has the Dutch nationality. So this Dutch case is actually looking a lot like someone who suddenly changed his status without even knowing what to do or in what kind of area one can live. So to make it concrete, Article 15 of the Dutch Act on Nationality says if you live more than 10 years outside the European Union and you have the double nationality, because a state cannot make someone stateless, of course, you lose your Dutch nationality automatically. And you don't get a notification unless within those years, within those 10 years, you ask for a passport or you request the family judge to establish that you're still Dutch national, which of course nobody does because these people didn't know that they were falling under this rule. And then what is even worse is that minors lose their nationality if their parents lose their nationality due to those rules. So what is actually happening in one of those cases, in this case of this Canadese woman, is that she had a daughter of, I think, 17.5 years old and a son of 19 years old. And her daughter lost her Dutch nationality because of this rule, whereas the son kept actually his Dutch nationality. So you get very weird situations here. What did the court do? Because this case went to the Court of Justice, and actually I was very much involved in this case also at the Ministry of Foreign Affairs, where I worked at that time. And actually a lot of people were arguing there, and also the Dutch Immigration Service, that Rotman should be interpreted as a very specific situation, not being applicable to these kind of situations. For us, if you remember the quote of paragraph 42, it's actually saying, like, because of the consequences and the nature, it falls within the ambit of European law. So there comes the European protection. The court said nationality regulation is up to the member states. So there's a legitimate aim. A member state can actually require a bond between the individual and the member state. So the Court of Justice actually agreed on what the member states did. And then with regard to minors, that's interesting, I think. The Dutch government argued with regard to minors, the legitimate aim is actually that the unity of the family with regard to nationality should be held on to. Which is quite weird, because in practice, as I just explained, we have now a son of 19 years old with the Dutch nationality and a daughter who is just 1 year younger who lost her Dutch nationality. So far, the rule of the Dutch government actually did not enhance the unity of nationality within one family. And you can also question, of course, whether that would be a good legitimate aim. So why is that important? And then the court said there should be an individual proportionality test. So the Dutch government also argued in this case that 10 years period is actually proportionality in the law itself. So we don't have to make an individual assessment anymore, because the law actually, if you are away for more than 10 years and you don't request it for passport in the meantime, then it's proportional actually to withdraw your Dutch nationality without notification. The court did not agree on that, so it said there should be a possibility for an individual proportionality test. However, the court said that should be ancillary. So the question now at the Dutch ministries, there's being a new law being made, there's a case pending, and we are still waiting for the outcome of the Council of State. The question is, how are they going to do that? So is that the people that are granting passports, or is it somewhere before in the process? Who is actually going to do that? And what is interesting is that the Court of Justice also refers to Article 7 and 24 of the Charter of Fundamental Rights. So as I said before, you see also in Chavez it kicks in. Whereas in Rotman the court did not mention fundamental rights at all, you see that the Court of Justice does so in the case of Chavez. And then the court says, what you need to assess is actually whether there's a disproportional effect of the normal development of family and professional life. And I have a question mark there, because I don't know what is then the normal development and what is then disproportional. So can there also be an effect on the normal development of family life which is not disproportional? So where are the outer boundaries? So what you see in Chavez, I think the Court of Justice gave a large degree of discretion to the member states. And I think it does rightly so, in the sense that it is indeed up to the member states to decide who are their nationals. So that's up to the regulation. On the other hand, it's a real threat, I would say, to European citizenship. And especially if citizenship is something you can buy. Because then the gap between people that don't have the abilities to use their citizenship rights and those who have money actually to buy that grows even bigger than it's now at the moment. But the good thing is that I think the fundamental rights narrative is becoming more and more clear. As I said, as part of the proportionality test, also here the Charter comes in. Then my questions on Chavez would be, as I said, what is the normal development of family and professional activities? I have no idea what is normal, what is disproportional. And then the court also mentioned for the first time in its case law the serious risk to safety because of a lack of consular protection, which is interesting as well. So to conclude, fundamental rights narrative continues also in chapters, and I think that's actually a good thing. However, member states still have a lot of discretion, which is logical in terms of the treaty. And what you really see is that the court tries to bridge between European citizenship and competences. So member states remain competent to regulate nationality laws. On the other hand, the court also has an obligation to protect European citizens because Article 20 is in the treaty. On the Dutch level, we have new challenges. For instance, there's a new law in place since a year, I think, and that's the possibility to revoke Dutch nationality from persons who are joining a terrorist organization. So we have a lot of ISIS or jihad fighters sitting in Iraq in camps, and their Dutch nationality is being revoked, so they can't travel back to the Netherlands. These cases are actually now pending at the Council of State, so I imagine that this will maybe also become a case for the Court of Justice. Then the chapter in the book is called "It's Nationality and European Citizenship, is it a strong feather or a slipping anchor?" I would say European citizenship stays as strong as its weakest link. So that means that we need very seriously to look at how nationality interlinks with European citizenship. So who is granting European citizenship to whom and on what kind of conditions. And European citizenship as such, but perhaps also the whole idea of the European Union stands at a crucial crossroad. So it's important also to see who are we going to protect. And then I would like to go back to the quote of Tindemans in 1975. They give it its social and human dimension. So I think it's time to also think, how can we give it its social and human dimension? And that might be something for BU Citizen 2.0. Thank you very much.
Thank you so much. Very, very interesting. And perhaps I can add that this could be the origin of the chance for administrative researchers to join the group, because there is a double level of citizenship seen from the point of view of nationality, which is administrative citizenship. Because we normally take for granted that in citizenship and nationality, there are, three actors: the individual, the national, the state, the member state, and the European Union. But sometimes also the role of the local entities is very important, because the local entities and authorities sometimes are able to grant people duties and also rights that from a constitutional perspective they don't have. And so also the, so to say, administrative citizenship could be useful in these cases, because European one is not the only source for rights. So perhaps the further developments could go also into this direction. Now, I'm very happy to leave the floor to Thomas Dudek, who comes from the European Law Institute, for his presentation. Thank you so much.
Thank you so much. And at the beginning, I wanted to thank Professor De Vries, Professor Duval, Professor Granger, and Professor Giurisprudenza for, first of all, inviting me to contribute to the book. Second of all, for inviting me to participate in this seminar. And my task for today, my task back then was to look into non-discrimination law and barriers that are resulting from in this area of EU law. And my task for today is to briefly present the chapter. So as you will see, I was looking into the framework, the EU non-discrimination framework, because my argument is that apart from practical barriers resulting from lack of funds, for instance, in order to bring non-discrimination case to the court, problems resulting from access to justice, there are also barriers, obstacles, resulting from the sole fact how the current EU anti-discrimination law is designed, how the framework looks like. Following the structure of the chapter, I'm going to set the scene. I'm going to first highlight why the problem is still persistent and important, and then I'm going to continue with characterizing the current EU legal framework with regard to anti-discrimination, which then will bring me to identification and of several barriers that I claim constitute problem with regard to protection against discrimination. Now, I was actually a bit happy that our seminar was postponed because in the meantime, Eurobarometer presented the data that concerned discrimination for 2019. In my chapter, I used data for 2015, and as you will see here on the graph, the numbers are getting smaller. So there is less respondents that perceive that discrimination on various grounds is widespread in their country. This applies for all grounds, such as ethnic origin or sexual orientation, religion or belief, and so on. However, what is striking is that the levels are still extremely high, and one can say that there clearly is a problem. The numbers are around 50% in any case. Another graph that you will see shows the experience of discrimination. So Eurobarometer was asking individuals whether they felt discriminated against on various grounds personally, and while in 2015, 21% people of individuals said yes, in 2019 it was 17%. Still, however, it means that 1 in 5 felt discriminated against on various grounds. This, for me, is an argument that action in the field of non-discrimination is crucial at the EU level. Now, the problem starts with various sources of EU non-discrimination law. In my chapter, I started with differentiating between the ground of nationality as a ground of protected discrimination and other grounds that are foreseen in other provisions of EU law. Now, the reason is that Article 18 of the Treaty on the Functioning of the European Union protects against discrimination based on nationality, and it is a directly applicable law. On the contrary, Article 19 of the TFEU, which mentions several other grounds of discrimination, is a competence norm. It doesn't give individuals the right not to be discriminated against, but it only gives competence to EU institutions to legislate further in order to combat discrimination on these grounds. And therefore, it could be said that Article 21 of the Charter, Article 21.1 of the Charter of Fundamental Rights, actually is a basis of a right not to be discriminated against. Now, another differentiation is that protection resulting from Article 18 of the TFEU applies only to EU citizens, whereas protection against discrimination on other grounds is not connected directly with the EU citizenship. It applies to everyone that is at the territory of the EU. Also, it's triggered when the discriminatory treatment occurs, whereas protection against discrimination based on nationality only applies when EU citizens are exercising their freedom of movement. So in my chapter, I go on with characterizing how the framework, EU non-discrimination framework looks like. And so apart from the treaties and the articles that I mentioned and the charter, another source of non-discrimination law is the general principle of equality and non-discrimination that is used by the Court of Justice of the European Union, but also several directives, so secondary law, which were indeed adopted on the basis of Article 19 of the TFEU. Now, I continue with clarification with characteristic of the law based on directives and based on the case law of the Court of Justice, because that's the most elaborative type of law. Now, based on that analysis, one can say that there are certain forms of discrimination that are foreseen in EU law: direct discrimination, indirect discrimination, harassment, but also instruction to discriminate, and also the one type that is used by the Court of Justice, namely discrimination by association. And there are several grounds of prohibited discrimination, as already, not yet mentioned. These are sex, religion or belief, disability, age, sexual orientation, race, and ethnic origin. Now, this brings me to the barriers. And first barrier that I came across is precisely dealing with various scopes of application of different sources of non-discrimination law. And the most important example is between the grants that are covered at the same time by Article 19 of the TFEU and Article 21 of the Charter. So these are those that you can see in the darker shape. And there are also grounds of discrimination that are foreseen only in Article 21 of the Charter. Now the problem is that it's not entirely clear what their status is. When I was drafting the Charter, it was back then still unclear as to the possibility of direct applicability in horizontal situations, so between individuals of Charter provisions. Now, with current case law, we have more clarity on that. Still, it remains a question whether EU effectively can protect against discrimination based on, let's say, genetic features or language, or in principle, grants that are covered only by the Charter. So for me, it's clear barrier because it's not clear whether individuals that feel discriminated against on these grounds can actually go to court and claim discrimination. Now, another group of barriers result from the characteristics and differences between the anti-discrimination directives. First of all, as mentioned, certain forms of discrimination are foreseen, direct, indirect discrimination, harassment, and so on, but certain forms are missing and are not recognized. Here, I mean, in principle, the multiple discrimination. So, of course, it's a different experience when someone is discriminated on one concrete grounds, for instance, for being gay, for instance, for being of Roma origin. And it's different when someone is sort of represents the mixture of several grounds and is discriminated, for instance, because of being Roma lesbian. Then their experience of discrimination is different, and currently EU law does not foresee that, doesn't provide for any answers in this situation. Another problem is lack of recognition of other grounds. So apart from the grounds that I currently mentioned, in my chapter I was thinking of situation of intersex people or transgender people. And then, so for instance, grounds such as gender identity or sex characteristics are not foreseen currently in EU law. One can argue that the situation is protected under the ground of sex or gender, but this is quite complicated, and in the history we know that, for instance, the ground of sex before adopting the Amsterdam Treaty and sort of including sexual orientation did not provide protection, effective protection for people representing being of different sexual orientations. Another big problem is different scope of application of various directives. So there is the so-called hierarchy of grounds. So we have a directive that protects against discrimination of race or ethnic origin, and it applies in the field of employment, access to goods and services, education, housing, and so on. But there are other directives, for instance, Employment Equality Directive, which applies only in the field of employment and protects on for other grounds, sexual orientation, disability, age, religion, or belief. Now, the EU is trying to do something in order to make the situation equal for all the grounds, but the horizontal equality directive is stuck at the level of the Council of the European Union. So this differentiation, this hierarchy of grounds persists. And further to that, there are different exceptions that are justifying discriminatory treatment, and it also differs on the ground of discrimination at issue. And last but not least, there are equality bodies, and also in accordance with EU law, they are foreseen only with regard to the ground of race and sex. So even though there are institutions, bodies that are tasked with helping victims of discrimination, conducting research on discrimination and representing victims of discrimination, the EU law actually requires them to focus only on race and gender. Now this brings me to the third barrier, namely the differences between EU level and member states level. The truth is that all the rules that I mentioned are EU rules, so these are like minimum requirements, and some member states went further and protect against discrimination or on more grounds in more areas of law. And this also holds true for equality bodies. Actually, only Spain keeps its equality body busy with gender and race, but all other member states actually broaden the scope of their work. And in order to conclude, first of all, as we can see, there is some progress since 2015, or since the time I was writing my chapter, but as mentioned, the problem persists and it's quite urgent. One of the ideas of the Commission was indeed to adopt the Horizontal Equality Directive, but the idea arose in 2008 and is still stuck at the level of the Council of the European Union. There are several member states who are against adopting this directive. In order to address that, the former Commission issued a communication in which it said that it will try to use the passerelle clauses in order to overcome that and in order to still be able to legislate on discrimination and ensure equal protection on various grounds. But again, this would require unanimity in the European Council this time. So, of course, there are certain hopes with the new Commission, as it's also apart from the new Green Deal and digitalization. The equality, ensuring equality and combating discrimination is one of the goals of the new Commission. But of course, further clarifications from the Court of Justice of the European Union will be required in order to, for instance, answer the question about whether the grounds of discrimination foreseen only in the Charter, what's their status. And further efforts by the member states will be required in order to ensure that in case EU is not legislating in the field, to ensure that individuals, while traveling across the Union, know what level of protection then can have. As currently this is a patchwork guild and a framework full of loopholes and lack of comprehensiveness. Thank you so much for your attention.
Thank you so much. Really interesting. Here, perhaps I'm too severe, and I'm telling it in advance. But here, perhaps I see a sort of parallelism with what Professor Hasopoulos told us before about economic rights. And perhaps there is a sort of paradoxical effect of the European legal system, because sometimes it seems to me that instead of producing an improvement of the degree of protection of rights which are protected first inside the legal systems of the member states, there is a sort of decrease, paradoxically, because of the existence of their formal protection inside the system of the European citizenship. And this is, in my opinion, the big problem of the whole system as well. I don't know if you agree.
I do, in a sense that I believe that, of course, what I presented is how the EU level looks like. Of course, at the level of national constitutions, the protection theoretically is broader. But again, these are concrete provisions, and it is unclear, as I mentioned, with the grounds that, for instance, not explicitly mentioned or that are foreseen in particular constitutions, but not in the Charter, for instance. Then this still requires clarification.
Sorry for making a question, but my idea was to open perhaps a short debate now at the end of the two sessions. If any of you wants to make questions, remarks, anything? Yes, please. Perhaps you could come here and use these ones. Ah, okay. In the bottom, perhaps there's something to...
Not working, okay.
Yeah, it does.
No, thank you very much for your presentation. So my question is, to what extent functionalism as a type of argument is still necessary to the survival of civil rights in the EU? Because I've been critical myself about this kind of reasoning of the court in the past, and I'm especially thinking about the common decision, where the court explicitly rejected any argument based on discrimination rights for a host of reasons. But now I found out, I read on a newspaper that common, the same-sex partner, was revoked the passport. So this was a case, very briefly, about a same-sex couple marrying in Belgium and going back to Romania. But of course, Romania does not recognize same-sex marriage, okay? So the court said that they have the right to go back based on freedom of movement, of course, but they rejected any argument based on discrimination, which was the big deal, actually. So my question is, given that there is a clear reluctance of some member states to deliver on EU rights, so they revoked the passport of this guy because they did not want to implement the decision of the court. So given that there is a pretty big variety of understanding values in the EU, is it still necessary, in your opinion, and I make this question to whoever wants to respond, is it still necessary to use functionalism and to refer to economic rights in the court's reasoning at this point of the EU history?
If I may, perhaps. You want to answer?
Yeah, I wanted
okay.
to have an additional question. So you say they revoked the passport, but did they revoke nationality or only the passport?
Passport. So in the past, they accepted both, but as soon as they got abroad, as soon as they went abroad to the US, namely, they revoked with an excuse the passport of Mr. Common, so no one is now allowed in Romania anymore. Neither of them.
Can I just add to that? I think in this particular case, the problem was that in Romania, Romania does not does not recognize same-sex marriage. So one of the partners, so they were relying on the fact that they're married, and therefore the other one was applying for the citizenship, but was not granted because Romania doesn't recognize same-sex marriages. Yeah.
But then, sorry, but maybe I misunderstand. But Roman was about a homosexual couple living in Belgium with the Romanian nationality, and they wanted to go back to Romania based on the B&O case, as to say. So they said we actually used our free movement rights. So then, if the Belgian passport is being revoked, how does that prevent them to go back to Romania? Yeah. So Romania actually revoked the Romanian nationality then, probably, because a passport is just a travel document, so then you cannot prevent your own nationals to enter your territory, I think. So, and then it would go back to actually what I said, one of the main threats to European citizenship, if this is true, it's that member states can actually decide to revoke nationality. But I'm not into this specifics of how they did it.
I'm not quite sure whether that was exactly the problem. I believe it was more that so one of men was from US, and he basically wanted to acquire a Romanian citizenship, which was not possible because of the fact that Romania does not recognize same-sex marriages. That's my understanding.
I may place a slight twist on the question. If you wonder about functionalism in a more institutional sense, that may be interesting also from a theory of integration perspective, that there actually functionalism might be very much alive if you think about the creation of the Fundamental Rights Agency, the introduction of Article 7, especially for fundamental rights, the rule of law mechanism or the rule of law dialogue. And some might say that actually maybe neo-functionalism spillover from other integration, similar to how the Court of Justice, of course, developed fundamental rights in this case law while there was still a European Economic Community. But that member state reluctance you point to, I think that also underlines the point that here, indeed at a supranational level, you can have all kind of niceties, but it takes two to tango, or maybe for this dance even 27 to tango. But then you do see with that Białowieża example I mentioned that apparently the Commission can force the hand in some way. And maybe for Romania, Poland, Hungary, even now with the whole judges question, maybe with provisional measures, still the court can apply the necessary measure of force to still make sure member states divert their course.
I just wondered whether the decisions in Bauer and the unpronounceable Finnish case that was decided a couple of weeks ago have an impact either in strengthening or indeed weakening your arguments, in the sense that it seems to me they are almost incomprehensible at a technical level. You could explain it in quite an abstract way, but and also it touches upon more general concerns that why is it that the Charter might have horizontal application in specific cases, whereas unimplemented or incorrectly implemented directives do not.
Yeah, maybe also we can frame this as struggling with subsidiarity in a way. So the whole scope issue and maybe the Pandora's box or Pandora's vase of Akkerberg Fransson, here the court itself would admit to the moment also it started with horizontal effect to also push it a little bit too far, and then now suddenly also realizing that maybe some, depending on the harmonization technique concerned, you still need to take a step back. And then in a way that Finnish case is quite logical. But then, as Van Ziel rightly said, indeed then, why say this lies outside the scope of European law? You might still, under Fransson, still be forced to say, as a court, within the scope, but then still we take a step back thereafter because of also subsidiarity and give the member states what should still be left with the member states. And I heard apparently that Koen Leenaerts recently at the talk, informally, in of course his personal capacity, said that with the whole air passengers' rights saga, he actually admitted that they went too far with Sturgeon and now have to mop up the whole mess with all the subsequent cases. And with the Sturgeon case, also with the whole passenger rights, talking about the airline passengers and their rights, if they had not actually, in that earlier case, started to twist a bit the sense of the applicable law. Now, maybe with the Charter you could say the same thing. At one point, maybe also Leenaerts would own up to the fact that they're trying to also, again, reframe Article 51 in a way that the member states and that kind of backlash, which you pointed to, that can be averted on the fundamental rights front. Because the indications, of course, are already there.
I think that's a very interesting question indeed. I've been bothered with that as well, with Bauer and TSN. Let's call it TSN, that's easier than the Finnish name. I think in Bauer what is so obvious is that you have two actually cases that are joined. One concerned a public employer or the municipality, and one a private employer. And in the one case you could apply the directive because it does have vertical horizontal effect, but in the other case you could not because it has been decided that it cannot have horizontal direct effect, and so that made it so obvious that it would lead to actually two different outcomes in a very similar, almost actually the same case. And I think one of the judges in that case, who was the author of the book on EU directives, probably also where she, I think in that book, argued in favor of a broader scope of application of directives, found this is actually very strange. This is one of the strange outcomes of the instrument of the directive that it can have. On the other hand, of course, it has a much more fundamental meaning, in my view, because the court also explicitly deals with the scope of Article 51 of the Charter. So that might explain why their broader view, partly explain, in addition, perhaps, to what Henry already mentioned, compared to TSN. We had a discussion about TSN internally as well in Utrecht, and there were very different views on that court's judgment.
I remember that I attended a presentation of you, Katrina, I think in 2010 or something in Brussels. I was a first year PhD student, and you talked about who's afraid of general principles of EU law. And because the issue is, of course, then, okay, directives do not have horizontal effect, but then it's being circumvented actually by the court by bringing in these general principles of EU law. So for me, the roots are actually there. So it would be weird if the court would not say the same about the Charter than it does about general principles of EU law, but it had a choice actually in Bauer. It could also invent like this new general principle of EU law being applicable, but instead of that, it applied the Charter, which is, for me, a sign that the Court of Justice takes the Charter really serious, so it's very Charter-centered. But I think they took already the step a long time ago. Well, general principles of EU law are actually also protecting people where the directives don't.
Just one sentence indeed again, there mind the gap. Also the Danish Dansk industry reaction, backlash against the earlier mangold idea.
Yeah.
So it seemed settled, and then actually after a number of years you realize one member state suddenly revolting, so careful.
True. Other questions? About the previous session as well, if you want. Speakers are here. No? Okay. So I think that we can leave the floor to our last but not least speaker, who is the big coordinator, Professor De Vries.
Big
floor is yours.
Thank you very much. I'm just going to see if I can start off my
Maar daarom gaat die hoofdjuist misschien nog meer op de Charter zitten.
I will keep it very brief, considering the fact that we have been okay.
Si è arruolata come speaker fino alla mia crisi, come c'è fino alla mia crisi.
Okay. Thank you very much, Anna, for giving me the floor. It's I don't know whether it's a very grateful job actually to be the last speaker when it's past 6:30. Although I know for Italians this is actually very early because you won't have any dinner before 9. But for the Dutch, we already had dinner, so you can tell me how much I have been suffering already. So, and then on top of that, actually, that my colleague Hanneke van Eycken said to me, well, you are the fun professor because the only thing you have to do is to sit here in the room and then just have some closing remarks. And actually, I think it was quite recently that I simply had to chair in Leuven. I think I had to chair 2 sessions. I didn't have to do anything. But I think it's actually a very daring task to come up with some closing remarks, particularly after all these thought-provoking, in-depth presentations of yours. And also considering the fact that we actually already more than 2.5 years ago, you could say we closed the BU Citizen project in Brussels. It was with our final conference. Catherine was there as well, remember, together with all the researchers, but also with stakeholders, European Parliament, European Commission members were present there as well. And that was I think it was a very nice conference, but it was also a very emotional conference for me myself. Remember that very well. the very last speech that I held there, and Hanneke referred to the logo. I have the logo also on my slides. So what I did, I was preparing just a few slides, and before I very quickly, not more than 10 minutes, I promise you, go through these slides, I want to thank, of course, people present here, to thank you all for these presentations, to thank the chairs, Louisa and Anna, for chairing this so well, the keynotes. Catherine, Daria is not present anymore, for having these wonderful keynotes. I would like also to thank all the institutions that made actually this seminar possible. And then, of course, last but not least, Elena, she's looking at the slides. She doesn't dare to look at me. But Elena, she was actually the one who was fully in charge of this whole seminar. So I was not allowed to do anything, I think, apart from the fact and listening and having these closing remarks. BU Citizen, I think Vasilis already mentioned that. It was much more about doing research. Actually, we became friends. And I even was allowed to borrow your very nice summer house in Greece, waking up, looking at the temple of Poseidon with my two sons there. It was, I think, one of the most wonderful holidays I had. Thank you so much, Vasilis, for that. So that is what I definitely remember from BU Citizen, that I slept in your summer house. But I also remember citizenship in practice. You have to remember, as young students, if you're going to do research or something else within the EU, you travel. We talked about it. You can cross the border without having to show your passport, unless there are certain circumstances that you have to show your passport. You might encounter delays, for example. Delays by plane, you might lose your luggage. So here, suddenly, EU consumer law kicks in. What's going to happen? This actually all happened during the 4 years that we did research. You encounter language barriers. We heard, of course, Elisabetta and Elena talking about the language barriers as well. And then in 2016, the bomb came, the Brexit referendum. 3 years ago. I remember that very clearly. We were in Spain, in Oviedo, and I think it was just after actually the referendum that we were sitting there, and actually we didn't really know what to do, how to proceed with our project. Because suddenly it appeared that one of the key member states of the EU would not be a member state anymore. And what are we going to talk about when we talk about EU citizenship? We were actually all flabbergasted, I think, because we didn't expect that outcome of the referendum, just like Cameron didn't expect that. Now, rather than taking a constitutional approach to EU citizenship, or having a very nice reference to, amongst others, the Odysseus, or what Henry mentioned, I take a more mathematical or architectural approach to EU citizenship. Because here we have the Vitruvian Man, and it happens so that actually there is an exhibition, I think, about Leonardo da Vinci here in Trento. That's what I understood from Elena. There's also an exhibition in the Louvre in Paris. The tickets are sold out for the coming period. That's what I know, because we tried to get one when we failed. But actually here we see three architectural principles. Structure, you could say, function, and aesthetics. Or structure, you can also say it's about the solidity. And I can use this picture for looking back at our project, for looking at present times and citizenship, but also for looking at the future and the challenges that lie ahead. Because we all heard, and Catherine Barnard talked about that, about the ideal of citizenship that has been there for actually quite a long time, and already long before the introduction of citizenship in the Treaty of Maastricht. It was the ideal of EU citizenship, the ideal of European cooperation, but it was also simply about non-discrimination. It was about free movement. And I just read an article, because I'm in the editorial board of the Belgian-Dutch journal, SAW, nobody knows that, outside the Dutch-speaking countries of the Netherlands and Belgium, written by Stefan van der Jeugd, who's working at the European Court of Justice. And he also, in actually the article that deals with the language requirements, new language requirements, English language requirements that are set by the Dutch state for accessing universities in the Netherlands, which are probably discriminatory. That is his conclusion, that the student mobility goes back in time as well, that student mobility was actually driven originally by European identity and the creation of a demos. And now it's more focused on obtaining professional qualifications. But that was not the original idea of actually student mobility. Now, what kind of citizenship have we been talking about, or are we talking about? What is European citizenship? I don't think we have really tackled that question yet. Is it, I just heard, is it market citizenship, or is it more than that? Talking about civil rights that we just did, is it more than that? Hanneke talking about Rotman, Catherine Barnard referring to the fundamental status. So is it indeed a constitutional concept, or do we see still many traces of a market citizenship? Now, I think in our project, looking back, the solidness or the structure of EU citizenship was a little bit taken for granted by the lawyers working in the EU Citizen project. Another question is, perhaps, how useful is the concept? We have also seen that it can be quite dysfunctional, actually, EU citizenship, if we look at it, how it is being perceived, perhaps, by the public in some countries, in some member states of the EU. But can it also be of help? And we refer to the backsliding of the rule of law in a number of member states of the EU. Could EU citizenship there also have a function? And how beautiful is EU citizenship? How inclusive is actually EU citizenship? Or is it per se an exclusive concept? Because you are an EU citizen, and then automatically you have also non-EU citizens, third country nationals. So citizenship, by its very nature, is actually an exclusive concept. But does it have also traces of inclusiveness? Those are questions actually that we dealt with in our project. And when I had one of my first presentations at the European Commission, Henry was referring to Yuri Borgman, he's not here. He was our project officer, and we were very lucky with him because he was actually a scholar in the field of citizenship. And together with Professor Malcolm Ross, he also wrote a book on EU citizenship. I said, well, actually, we are some kind of scouts group together of researchers, and we are looking into various pathways leading to EU citizenship. And these pathways were actually not merely legal, but because we had also historians on board, and we had social scientists, philosophers, we had even an economist, we had people from the public administration field, political scientists, so we were a whole bunch of people coming from different disciplines, and we were sent out in the woods, in the forest, to look at these different pathways of citizenship. And then, of course, we as lawyers, we were looking, because that's what we are used to do, at more rights, you could say, and the barriers to the exercise of the rights. And some of the key findings we heard today and were presented to you, but then, of course, we have these 8 books, so there are more findings there. And I looked up, actually, it was some time ago that I did, we had even a press release that I made with a former BBC, actually, journalist, which we presented at the final conference in Brussels. So, for example, one of the key findings, we need to look beyond a one-size-fits-all EU citizenship. Local, urban or regional citizenship are useful models and can be combined with national and EU citizenship. And Anna already referred to that in a way. Those were the historians looking at, you could say, development of citizenship from before the birth of the nation state. Social rights, they significantly differ amongst the member states. Should we introduce a European minimum income scheme? Frank van den Broeke, who was not part of our project, he is one of the proponents of that, and that's actually quite a topical issue, again, on the agenda of the EU. Civil rights, a confusing framework, that is what Thomas actually explained to us when it comes to discrimination. And those who are non-mobile EU citizens, the sedentary, the stay-at-home citizens that Catherine Barnard also referred to, the biggest group, can they benefit actually from all these rights that the EU has created? And what about political rights? Vasilis actually explained how destructive the economic and monetary union actually has been in respect also of political rights. Now, you could say, I'm always trying to look at things from the bright side of life, so having a more positive outlook. We have to be critical, but let's also look a little bit more positively. So, what happens? Some of our key findings are echoed in von der Leyen's agenda. Because, as Thomas already explained, non-discrimination is mentioned there, and it's quite high on the agenda. The social market economy, Catherine, is mentioned by von der Leyen. We just wrote actually an article on the social market economy, and it's there in the treaty, but can we find it somewhere else, actually? And that's quite disappointing. But now, again, it turns up the social pillar, the pillar for social rights, for example. So you could say we find references more to social justice, which is very important when we talk about EU citizenship. We even have the very contentious commissioner protecting, or was it promoting, the European way of life. There was a whole discussion in the European Parliament that the word protection should be changed into promoting. Because that is, well, you can imagine why when we talk about European identity and so on, then again we come to the discussion of inclusion and exclusion. What is actually the European way of life? Some would say, well, that's easy, I have an answer to that. I don't really have a very good answer to that. And sum up some things. So we're going to see what that actually means for social justice. New challenges. Are they new? This challenge was already there, but that was at the end of our BU Citizen project. Brexit, of course, has an impact on the foundation, the foundational value of citizenship, but simply European citizenship in itself. Its structure is being affected right away. But as Hanneke mentioned, what is very interesting is what happens with the acquired rights of the Brits once they have lost their EU citizenship. I think that might be an interesting question for the European Court of Justice to consider. And that actually touches perhaps on the usefulness of citizenship. Is citizenship, EU citizenship, even for the Brits, still a useful concept after the 31st of January? Hopefully it is, actually. Now then, what we have not really talked about, what about the digital citizen? I think was briefly mentioned as well. Digitalization has a huge impact on citizenship and citizenship rights. All kinds of rights. And at the same time we see that, for example, private actors play a predominant role in the digital internal market. Someone was mentioning, that was Paolo, he was mentioning the digital single market because their copyright issues play a role, but also other fundamental rights, freedom of expression. And what about Eva Glaziewicz-Piecznik, who was suffered, she was a Green politician in Austria, and she actually suffered from hate speech. What should Facebook do? Should it indeed take away certain messages? And what are the responsibility under fundamental rights of private actors? These are questions that are now very relevant in our current times. But also political rights. Think about Cambridge Analytica, for example. The question, to what extent digitalization also affects our rule of law and democracy. And then thirdly, of course, I should mention the person of the year according to Time magazine, and that is Greta Thunberg, the Swedish protester for combating climate change and environmental deprivation. And here you see the picture of Leonardo da Vinci on melting ice. So is indeed not ultimately climate change and environmental deprivation, does it ultimately not have an effect for the core values of EU citizenship? does it not sort of challenge citizenship in itself? Another question, by the way, that is raised by Greta Thunberg and all the sort of school kids that are going to the streets and protest for combating climate change is these are children, minors, that cannot vote yet. They have no political rights in that respect. So should they also sit on the table with the policymakers or not? Maybe raising new questions when it comes to citizenship rights. Which brings me, of course, to something positive as well, and that's the European Green Deal that is presented, or was presented, I think it was yesterday or the day before yesterday, as part of von der Leyen agenda. Now, all is about, is Europe going to adopt the Green Deal? Is it going to implement it? How does it resonate with the member states? And then how is it put into practice? Because we heard a lot about citizenship, we heard a lot about constitutionalization, but it needs to be put into practice, and it's, people should also be open to that. Yeah, and that brings me to my almost last slide. What about the future then? Shouldn't we actually design, and I invite Trento University, because it was great actually to work with Trento University, one of the strongest partners, I have to say, in the team. Of course, Vasilis, you were there as well. Please join as a University of Athens as well. Should we not build up a new consortium? Because there are so many questions and we don't have the answers, neither has Harry Potter looking in his ball. So, and well, Catherine just left, but she will return. Maybe we can still find a way to involve a UK university as well, even after Brexit. I would like to thank you very much and enjoy the evening. And of course, later on, for you as students, a very nice Christmas holiday. And well, before that, you have to do your exams, I think. Good luck with that. I hope you get a lot of questions that relate to our seminar, because you made good notes. I'm sure about that. And Elena, once again, thank you. And the Trento team, Paolo, Elisabetta, she is there. Flavio, you are there as well. So here we have a very strong Trento team. Give them a warm applause. Thank you.
Now, we still need 1 minute of your time because, well, Catherine just left, but we have a small present to our big coordinator and to Professor Catherine Barnard. The present is delivered by, this way, yeah. But one of the students, of the English course, who, if I'm not wrong, comes from Matera, that is the capital of culture, together with Plovdiv, for a short time, yes, together with Plovdiv in Bulgaria. And so this is for Sibe, yes, yeah. And then during dinner we will give it to Catherine. Okay, thank you. And it's a present, well, it was meant to give you an invitation to come back, but in your case, you will be back to Trento as a visiting professor. You don't know, but we will be asking to work a lot. So,
this is my sabbatical, Elena.
Yeah.
Thank you.
Okay, but thank you very much. Thanks a lot, Sibe.